presiding. Please be seated.
All right, we are on defense prisoner and represented by counsel. We are, just so everybody knows where the court is this morning on things, we've got a couple jurors that we're trying to follow up on just to make sure that we have them and they're available. That process is ongoing, but in the meantime, I was told that there was a request, at least Mr. Goff had made a request to convene prior to selection, and so since we've got the time to do it right now, I figure we'll go ahead and convene in the courtroom. So, Mr. Goff.
Your Honor, for the delay this morning, I actually came and started to set up in here before I was told we were going in there. I didn't mean any complications. I've got 6 matters, which for me is good, given the magnitude of this case. Case of this magnitude. Issue number 1 is the underrepresentation of what I call Bubba or Joe Sixpack in the jury pool. I am constrained, having spent several days looking at the record in this case and seeing where this goes, irrespective of whether Bubba or Joe Sixpack is a cognizable group for that purpose. I can't see, it's not that I don't want to raise the issue, I can't see in this record that we have how I can do that, how I can meet all the steps involved. So what I'm asking the court to do at this time, have an abundance of caution to protect the record, because years down the line I'm not going to remember any of what happened over the last couple of days. I do want placed in the record, under seal and preserved for appellate review and for motion for new trial, all of the juror cards, all of the questionnaires for all of the jurors that were summoned in this case, which includes the first group of 200, I don't remember, it's 260 or 289 of the original 600. I want all of those questionnaires preserved and made part of the record, kept under seal for the privacy of the jurors. And I also want all of the juror cards and questionnaires for the second set of 600 jurors, however many appeared, 400, however many appeared. I want all of those records preserved and placed under seal for the privacy of the jurors, but made part of the record so that appellate counsel, in the unlikely event that there was a conviction in this case, that appellate counsel would have a record to determine whether or not, since this isn't a strategic decision, Your Honor, whether or not there was an issue of ineffective assistance of counsel. If the record was there and I simply failed to figure it out, then that would be an issue that might be relevant to appeal. So that's really all I'm asking this morning, is that that information be preserved in the record for appeal and placed under seal. That's issue number, I have it in issue number 0 on my list of issues.
Maybe the easier way to do this for efficiency's sake is get through the issues, and then I'll let everybody address what they believe they need to address on behalf of their client.
Very good, Your Honor. Issue number 1 is Juror 219. Juror 219 was examined in court, and it subsequently has turned out that there was an undisclosed social media account, a TikTok account, which contains, I was originally told 3, then I was told 4. Apparently now it is 10 dance video tributes to Ahmaud Arbery that were posted over a period of a month from early May to early June of 2020. The first issue with that juror is with respect to whether they had been candid with the tribunal. Between the general questions and the specific questions, she was certainly obligated to notify us of that account and any connection to Mr. Arbery. And Your Honor has gone to great pains during jury selection over 2 weeks to evaluate the emotional connection that jurors have developed with Mr. Arbery, whether that is a familial connection, a historical connection, or just an emotional connection. People that are watching the video 40 and 50 times, people that have taken upon themselves to go out and play Nancy Drew, for lack of a better description. The fact that these videos were taken, aside from the candid record issue, there is the issue of whether it's an emotional connection. I have asked the state to consent to the excusal for cause of Juror 219. I don't see any way, I won't say I don't see any way. I'm deeply concerned that this could be a traumatic, if we bring this juror back in, this could be unnecessarily traumatic and challenging, and I just don't want that. And given the notoriety this case receives, you know, certainly if this juror is selected, every media outlet in America will be crisscrossing TikTok trying to find what we're talking about. And I just think that would be unfortunate and unfair to this young lady. So I'm asking, if the state won't consent, I'm asking the state to go ahead and excuse her for cause without bringing the juror in. If the court feels the court needs further examination of the jury, we can certainly do that. Your Honor, I will advise the court that at 10:02 p.m. last night, I emailed the state the links to the 10 TikTok videos, so they have had ample opportunity, if they chose to do that, to review those prior to, well, I don't know when they review it. I'm sure they had to sleep at some point, but I've done the best I can to provide that information to them. Shall I move on? Your Honor, I'm concerned that we need to inquire of the jurors, the entire panel, which we certainly can do. I would just assume have the court do it in the courtroom. If any statement previously made, whether on the juror card, the juror questionnaire, during the general questioning, or during the individual questioning or examination of the potential jurors, after further reflection, whether they believe any of those statements were incomplete or perhaps untruthful, they should raise their hand so they can be individually examined. This addresses two issues that I have raised during jury selection. The first issue being that the parties are relying largely on unsworn statements. And second, the issue that we've already had one juror who's if I recall, whose answer changed, and another who contacted the court after they were examined. In that, given the length of jury selection, that they may have remembered things or other matters that may have changed since they were in here. So I think that general question, if any statement previously made by you, whether by juror card, in filling out the juror questionnaire, or in response to general questions or individual examination, is incomplete or perhaps untruthful in any way, please raise your hand and then individually examine those jurors. That is issue number 3. Issue number 4 is the motion in limine, which was filed this morning at 8:29 or 8:30, Your Honor, and that is a motion in limine which is being raised this morning because it dovetails into the severance issue which I advised the court we were looking at last night. It is a motion in limine to exclude evidence, argument, and jury instruction as to any purported conspiracy after the fact. Your Honor, there's been a long history with respect to a particular jail call in this case, in which Mr. Roddy Bryant is portrayed, a conversation that he's not a part of, as a quote-unquote ally of Greg McMichael in this case. At first, it wasn't coming in. Now, if I understand correctly, the court has ruled generally that jail calls can come in, although I don't think the court ruled on that specific one. In the state, and give credit for skill as an advocate, the state has been quite coy as to whether they're pursuing that. There is also extensive discussion in a number of witnesses, including a GBI investigator in this case, with respect to what the jurors and the public may view as a mystery as to how the video in this case got out into the public domain. And it is unclear again where the state is going with that. And of course, the state may want to say that it's not part of our case in chief, but we're going to reserve it for rebuttal, and I'm not sure in this case what that really means. But my concern here is that there is no evidence that I'm aware of from the beginning of this case till I stand here today to support any jury charge on conspiracy. It's not there. Now, the state is certainly entitled to a charge on parties to the crime. I understand where that's coming from, but especially given the fact that they have that charge, there's no basis to be charging a jury on conspiracy. And when the state starts presenting evidence of conspiracy after the fact, even if it's to prove the conspiracy before the fact, it's the Jackie Johnson cover-up conspiracy is irretrievably intertwined with this other state after-the-fact conspiracy theory. If it is, I'll back this video. And what that does for me, Your Honor, is it's difficult to say right now whether there is any antagonism or how serious the antagonism is between defendant Bryan's defenses and the McMichael defendant's defenses. But more to the point, and why I'm bringing this issue up this morning before Your Honor, is we're in a position of antagonistic jury selection here, where jurors that are perfectly capable of serving and certainly could be fair and impartial, Mr. Bryan, have expressed concerns about the length of time between the arrest, between the crime, alleged crime, and the arrest. They've expressed concern about Jackie Johnson and, of course, Mr. McMichael. Obviously, we understand where that's coming from. But if the state is going to be allowed to directly or indirectly present any evidence after the fact, after the shooting of a conspiracy between Mr. McMichael and anybody else, there's just no way the court is going to be able to limit that door once it's opened, and it's going to be getting into matters that are going to put us in a difficult position. And what I'm asking the court to do right now, well, before we start jury selection, is to go ahead and address this conspiracy question, which it's technically a jury charge question. A lot of times we don't discuss jury charges until the end of the case. But in this case, this conspiracy matter is extremely important because it goes to the antagonism between defenses. It goes to the antagonistic jury selection between these defendants. And it directly impacts whether we file a motion to sever and whether we are compelled to do it now or we can wait for the presentation of evidence and see how that evidence develops. I could be wrong, but I think I know where the court's going to be on this, and I think when pressed, the state is going to give up this conspiracy theory because it just creates all kinds of, it's a Pandora's box. But I would like to know where we stand before we start. Mr. Bryan has to make, unless, if I'm right, we could raise the issue mid-trial. The court may not agree with that. And I certainly don't want to put Mr. Bryan in a position where he has unknowingly or unintelligently waived his right to a severance. So that's why I want to address this motion in limine right now. It shouldn't take too long. To me, it's pretty simple. The idea that anything that transpired after the shooting in this case is somehow going to establish a conspiracy either before or after with respect to any issue in this case is fanciful. I think the court could eliminate all of that under 403. The prejudicial impact of that kind of evidence would so far outweigh its probative value that it wouldn't be in any way. But I don't want to be in the middle of the trial and be having this discussion, especially if the court's then going to say that Mr. Bryan has waived his right to raise it. That's issue number 4. Issue number 5 would be a motion to sever. I'm not going to make that motion until we know what the ruling is on 4. And last but not least, Your Honor, we are statutorily, whatever the court rules on Juror 219, whatever that ruling is, defendants are statutorily entitled to 15 minutes to confer before actually exercising their strikes after all the jurors have been qualified. In this case, there are 3 defendants, 7 lawyers, and 65 potential jurors as we speak, maybe 64 in a few minutes. The lawyers have been working extremely hard. I was waiting till midnight to get some clue as to what was going on in the other camp with respect to jury selection this morning. They reached out to me this morning when I was indisposed. We had about 10 minutes to discuss this before we got started. So I'm asking the court, after the court rules on 219 and before we start the examination of the jurors, I'm asking the court, instead of granting 15 minutes, to grant 60 minutes for counsel to confer. Now, beggars can't be choosers. If we can't have 60, I'd take 45. That'd be 15 minutes each. But this is the most complicated jury selection that I've ever been a part of, including several death penalty cases. I think we're entitled to that under the circumstances, understanding the broad discretion the court has in these matters. Thank you, Your Honor.
Anything from the McMichael defendants on those matters?
Your Honor, I would agree that the questionnaires should be filed and left with the court under seal for this record. Other than that, I don't have a comment on the other issues.
From the state.
Thank you, Judge. All right, I'm going to try and take these one at a time. I understand issue number 1 was underrepresentation of white males over the age of 40.
Well, I think what that was Mr. Goff explaining his theory on that, but indicating at this point the request would be to go ahead and seal into the record that juror information.
Correct. And simply for the record, at this time, jurors 1 through 48, we have 19 men and 29 women. We have 36 white jurors and 12 black jurors. 9 of the jurors are white men over the age of 40. That means they're 19% of this panel of 48. So almost 20% of the jurors are white men over the age of 40. We only have 6 black males, and that would be only 12% of the jury panel. And simply also for the record on this issue, as Mr. Goff said, ineffective assistance of counsel coming forward, Larmon versus the state, which is 177 Georgia Appeals 763, which is a 1986 case. As the court knows, a defendant is entitled to an array of properly drawn, impartial jurors to which he may direct his peremptory challenges. A party is entitled to this matter of right, but conversely, he is entitled to no more. A defendant is not constitutionally entitled to a veneer or jury roll of any particular composition. It just must be picked from the rolls. In addition, Jackson versus the state, 294, Georgia 431, a 2014 case. Any objection to the jury array? In that particular provision, the defendant has the burden of proving purposeful discrimination in the composition of the jury array. That would mean purposeful discrimination by the clerk of court in who the notices were sent to, and that is the burden in that case. At this time, the state, of course, has no objection to making all of the juror cards and questionnaires part of the record. Thank you.
The court intends to go ahead and seal that information into the record, then. That should address issue number 1.
That's just all of the jurors.
Yes, those that have, yes.
Thank you.
I understand the request.
And then, Judge, regarding juror 219 with the TikTok account, yes, we have been working 12-hour days and receiving an email at 10 o'clock last night. I was asleep, so I had an opportunity to review it this morning. These are only, I'll call them dance videos, from May and June of 2020. She is a dancer, appears to be professionally trained, and there are many, many of them on her public TikTok account. At this point in time, it appears that she tagged them with hashtag #RunWithMaud. There were some heart emojis, but there was nothing after June of 2020. The state would object to dismissal of her based on not being candid with the court. And this juror was questioned before we ever asked about #RunWithMaud or anything along those lines. So she was in the panel that was questioned well before we combined Black Lives Matter and #RunWithAhmaud questions. So she was actually never asked about this and never had the opportunity to address it. So I leave it to the discretion of the court as to what the court wishes to do to bring her in here if the court feels she needs to be questioned. But as the court pointed out last night, that's what peremptory strikes are for, to be used when you discover additional information. For instance, Your Honor, this morning I let the defense know that we had discovered Juror 291, and I have printouts of this, some additional information from her boyfriend's, or now her husband's, Facebook page about when he went ahead and proposed to her. He was wearing a t-shirt that had a Confederate flag on the back of it. And that's something I revealed to the defense this morning so that they're aware of it. I'm not going to motion right now to have her struck for cause, but obviously there's an issue there about something that we have now discovered. So we leave it to the discretion of the court on Juror 219. Regarding...
I'll wait. Or do you want me to address?
Let's get through the responses. We'll just try to keep it in order that way. Okay.
I think issue number 3 was asking all of these jurors to raise their hand if a statement previously made after reflection is incomplete or untruthful. I have no idea how many jurors are going to raise their hands, since we may be opening a floodgate to, oh yeah, I forgot to tell you this, and by the way, here's all these reasons why I'm now not qualified because I really went home and don't want to be on this jury. The relying on unsworn statements in the questionnaire, the defense is the one who initially requested the questionnaire and has had ample opportunity to repeatedly review it with these jurors and get their sworn testimony about the questionnaire. So that is a red herring in the state's opinion. And would they have remembered other things that they want to tell us? Maybe, but we're asking that we not redo individual voir dire of all 65 of these jurors this morning, Your Honor. Regarding the motion in limine that was handed to me this morning at 8:30, as the court is aware, a conspiracy can be a tacit agreement, and the conspiracy charge that the court would give per the request of the state would be that a conspiracy can be found before, during, or after, and it's something for the jury to determine as to the existence of a conspiracy. And they're charged that you can look at what happened beforehand, and we all know that beforehand Mr. Bryan's phone number was not in Mr. McMichael's phone, and Mr. McMichael did not have Mr. Bryan's phone number in their phones. What happened during, the state's argument is going to be, is there was a tacit agreement to go ahead and do what they did on February 23rd, 2020. The fact of the matter, afterwards, what Greg McMichael did to make continued contact with Mr. Bryan, to actually go to Mr. Bryan's place of work, to ask for Mr. Bryan's phone, to take Mr. Bryan's phone from him so he could take it to his attorney, to then download the video so Mr. McMichael could, I guess, get it published for whatever reason he wanted to do that. The state had not anticipated that necessarily coming in at trial. That was not going to be one of the things that we went over because that's in Mr. Bryan's first statement to Agent Seacrest. And the only way that it might come up would be on cross-examination of Mr. Bryan, I believe, by the defendants and or the state, depending on his testimony. So at this point in time, we have no intention, if I may have 1 moment. In our specific case in chief with Mr. Bryan's statements, we don't anticipate it becoming an issue. Now, I can't predict what's going to happen in the defendant's case in chief and what the state might decide to do with rebuttal. So at this point in time, I think this is completely premature to ask the court to make a decision on a jury charge or to lock the state in to promising that this evidence won't come out when I have no idea what the defense is going to be in this case, Your Honor. the state has no opinion about 60 minutes to confer based on any rulings that you would make, Your Honor. I leave that to the discretion of the court. Thank you.
All right, final word, Mr. Goff.
Your Honor, the state has acknowledged, I believe, that they've had a chance to look at the TikTok videos, and I don't think there's any dispute that they say I want withdrawn or they're hashtagged. As the state acknowledges, on at least one of them, there's actually a heart emoji in the tribute video to Ahmaud. The state argues that these 10 videos were posted at different times over a month period, but a year ago, so that's not relevant. Your Honor, with all due respect, we're excusing jurors for contacts with people that are 5 and 10 and 20 and 30 years old. So posts from last year are still highly relevant. More importantly, Your Honor, in her juror questionnaire, she was asked about her social media. And obviously, she's a frequent TikToker. She's got more videos attributed to Ahmaud Arbery than I have posted in 12 years on all my social media accounts. Clearly, this juror has an emotional connection. We can bring her in and we can talk about it. But clearly, there's an emotional connection to Mr. Arbery. And there's just, we got plenty of jurors here. There's no reason to put this woman through that process. And bearing in mind, until the jury returns its verdict, and even afterwards, these jurors are going to be scrutinized, perhaps for years to come. I think we saw that in the Floyd case. And this is just an unnecessary landmine on Juror 219. Unnecessary landmine. We're certainly entitled, both because of the lack of candor and because of the substance of the videos, to voir dire the juror on those two subjects. Moving off of that issue, because I believe after all the discussion, my first request with respect to the record is granted. That's the second issue. My number one, their number two. My number two, their number three, is with respect to asking the entire panel my issue to their number three is we're asking the jury, not the jury, we're asking the court to ask a single question of the jury panel with hands raised for any individual examination that may be required. It may be none. If there are hands raised, then I would suggest that we would all, and I would think the state would also be interested in knowing whether they're relying on information that is no longer correct. Your Honor, and again, the way I have the question phrased is if any answers previously given have changed since submitting your juror cards, juror questionnaires, during your responses to the general questions, and during the individual examination, whether after further reflection you believe that any answer previously given was incomplete, or whether the information provided or omitted might no longer be truthful. And I will certainly defer to co-counsel of the state or the court as the exact wording of the question. My concern here isn't, first of all, to ensure a fair trial, because we certainly want jurors that are selected based on accurate information. And over 2 weeks, it's inevitable that some of the answers have changed, that people will remember things. It may also be that some of the jurors have thought about it and realized that maybe they didn't give truthful answers or complete answers. And I'd rather give them the opportunity to correct that than to be in an ugly situation during the trial or afterwards when things come out. And unfortunately, I have every reason to believe that that kind of thing will happen given the nature of this case. This is not a red herring. This is also an ineffective assistance of counsel issue. And while this issue may be new to the state, I have complained about this issue for years. And apparently, I'm just the crazy guy, okay? But it seems to me that reliance on unsworn testimony, whether by card or questionnaire, is ineffective assistance if it turns out that the information turns out to be incorrect, because the juror is not subject to any real sanction if they're not required to answer and provide the information truthfully. It's an ineffective assistance of counsel issue here, and the only way to cure that issue is for the court to essentially, without necessarily doing it directly or in a way that's obvious to the jurors, is to effectively have their answers be truthful, which is you cover by asking if any answer previously given was untruthful or incomplete. It addresses that issue. It cures any ineffective assistance of counsel claim with respect to the lawyer's use of the juror cards and questionnaires that were unsworn. And there is no other way to do that. And I don't think the state addressed the other reality, is that things change. And just since Monday, October 18th, when we started this process, in what feels like a year ago, a lot has happened in this case, and undoubtedly a lot has happened in these jurors' lives. And for that purpose alone, it is appropriate to ask that follow-up question. I don't think more than 2 or 3 jurors are going to raise their hands, but if it were 20 or 30, it doesn't matter. Our objective here is to have a fair trial. Your Honor, with respect to the motion in limine, I think the state's argument made my point. The state is asking the jury for a jury charge that the jurors can infer the existence of a conspiracy after the fact. The problem is, if we let the jury speculate on whether there's a conspiracy after the fact, now it gets into all the Jackie Johnson cover-up stuff and all these problems with defendant McMichael, which don't impact Roddy Bryant, but it certainly impacts jury selection because the lawyers have to strike juries based on that. And there's no way, although I'm not saying that the state is consciously trying to get into matters that they shouldn't get into, but there's no way you're going to unpack any of this after-the-fact conduct, which they're reserving the right to present. You can't unpack that from the broader issue of that delay or lapse in time and this supposed Jackie Johnson cover-up, which I don't put any stock in, but it doesn't matter what I think. The concern is what the jurors are going to be doing with the charge of the court and the information we provide. I would ask the court to go ahead and rule at this point, subject to a motion to reconsider from the state, that the court's not going to instruct the jury about conspiracy after the fact. If they're going to infer a conspiracy, they've got to infer it from the conduct before or during the shooting, not from things that happened days or weeks later, particularly issues involving unelected officials or no longer elected officials. Your Honor, the state cites a correct principle of law as a general rule, but as applied to this case, it's factually unsupported. I think they agree at this point that it will be factually unsupported unless their position changes. But the practical matter as far as antagonism between defenses, and especially antagonism in jury selection, is normally you make a motion to sever before trial, not in the middle of it. And there is some case law that says you can do it during the middle of the trial. But I certainly want to make it clear that we're preserving the right to move to sever if this conspiracy thing comes in. But even then, it still is a problem in jury selection. We can't change the jury after we've picked it. And we have a lot of jurors who are deeply concerned about this supposed cover-up, this conspiracy between Jackie Johnson and George Barnhill and Greg McMichael and who knows how many other people. And inevitably, Roddy Bryant gets drawn into that, even if despite the state's best intentions. So I think that is an issue that needs to be clarified. And I will leave whether we get 60 minutes, 45 minutes, I'll leave that up to the court. But I think the court can understand the complications. And until the court rules on the motion in limine, I don't even have a good feel for how important this issue is during jury selection.
Okay. Again, on that, the first issue, which is the record, again, the court has indicated, I'll go ahead and seal the questionnaires and the cards. As to 219, I had intended to, and I just got sidetracked this morning, to go back into my notes and see what exactly 219 was examined on and where that fell. Based on that review, I'll make a decision on whether 219 gets called back in to discuss this limited issue of what these TikTok videos might be or might indicate. I am not going to ask the panel of 64 the question presented. There was, each party was provided ample opportunity and time to ask questions, and the record is replete with answers from all of the jurors to those questions. I'm not intending to reopen jury selection, which is effectively what that question would ask the court to do. As to the motion in limine, I do believe it's premature. I understand Mr. Goff's concern about it, but it almost feels like hearing the state and Mr. Goff talk about what this conspiracy after the fact is. It's almost like apples and oranges a little bit. They're not getting a real connection on specifically where we're going with it. Generally, I will look at the evidence at the end of the case to determine whether a charge is appropriate. if that charge is appropriate at the end of the case, we'll go ahead and address that. I do understand and respect the defendant's concern about where Mr. Bryan may fall within that legal theory, but without hearing the evidence or understanding exactly what the state's theory of the case is going to be, at this point, I think it would be premature for the court to make a ruling on that motion. But I do understand that that right is being reserved to go ahead and raise the issue again. I understand where we are, but at this point, I think we're premature.
The only thing I would add, and I'll be brief, is once we started the trial, we're stuck isn't the word for it. We have the jurors we have. That may limit the court's remedial options at that time. I'm just given the complexity of jury selection in this case, I just thought I would point that one thing out. I have nothing else to say.
As trial goes on, we all get painted into corners, so that's where we are. I understand. As to the motion to sever, I understand the defendant's position right now. We're putting that on the record. And as far as time to confer, I'm still trying to work through the panel. There's time now to start talking about it, and I'm trying to figure out where we are numbers-wise. I would like to see counsel and chambers about that so that you all can just get an update on where the court is numbers-wise. Anything then beyond that I'll just start on my left, from the state.
Just an inquiry as to whether the court would reconsider the state's motion to excuse for cause juror 466. Having pulled juror 466, my notes from last night, once again, his wife works with Lee McMichael in the exact same department with her. Wife is in medical records. Lee is not her supervisor. However, it would put my wife in a weird situation, possibly if the jury came back guilty, put her in an impossible situation at work, probably a better chance that he will not be fair and impartial due to his wife. Wife can supersede objectivity. It would be on my subconscious, and that is why we're actually motioning at this point in time to excuse him for cause. And it is the state's failure for having not motioned at the time. I understand that, but we wanted the court to see if the court would reconsider this.
The court's position generally on any reconsideration is if there is no new information, nothing available to the court that would require reconsideration, then the court will not move on that. So as far as I'm concerned, again, the parties had ample opportunities to examine the potential jurors, and also then had an opportunity to consider the motions that were being made as well as the court's ruling. The court ruled. Remains the ruling of the court.
Thank you, Judge.
Anything from Travis McMichael?
No, you're not listening.
From Greg McMichael?
Just one moment, Your Honor. We may have one short motion to make in just a moment, based on something the court just said about reconsidering a juror for whom extrajudicial information has been acquired after the voir dire examination.
I don't think that's not what I just addressed. What I just addressed was information that was known to the parties at the time the court made the ruling.
Right. And that made me infer that if the information was not known to the parties at the time of the examination and has since been acquired, then a motion that was not made when we did not know the information could then be made, as was just done by the state, but based on information we already all knew. We may have one juror, potential juror, about whom we have acquired extrajudicial information not acquired during the examination of that juror. If Mr. Rubin is prepared to go forward on that, you have that?
I do. And Your Honor, I was going to raise that issue. It was suggested to me. I'm just trying to be a team player here, but I'm sure I know which juror this is, and we're going to be joining in that.
If the court will indulge me.
I'm not sure what I'm indulging you in, so
Your Honor, we would move to strike for cause juror number 140, based on information we learned after he was voir dired a week or so ago. Juror 140, in response to questioning, admitted to having an arrest out of the Bronx, New York, for a misdemeanor, I think is how he put it. My notes don't reflect he disclosed anything else, and I admit my notes are not as good as Ms. Hoag's, and may not be as good as the state's, but he admitted an arrest for fighting in New York, and he had no opinion on how he was treated, I think was the follow-up question. Our information, based on investigation, is that, in fact, Juror 140 had multiple arrests and convictions, all for misdemeanors, that we can tell, based on New York law, stemming from as far back as the 90s, mid-90s, 2002, 2004, 97, multiple arrests for what looks to be either a stalking or harassment type offenses, and with protective orders as part of the sentence. Some periods of imprisonment, 5 days or a couple months. Again, nothing that rises to the level of felonies, but the lack of candor from the juror, it was concerning to us enough that we followed through with getting the New York records. And given the additional information, given his lack of candor, we would move to strike. And I can show this date. I don't have it printed out, but I can certainly show this date. They may know this already. But we would move to strike juror number 140 for cause based on this new information.
I understand that Mr. Bryan's joining the motion from the state.
Judge, I have no information. This is the first the state is hearing of this morning. I am going to ask my investigator to look into this, but it appears the representation is it's a series of misdemeanors. So there is no felony conviction here, and it appears that this juror was born in 1977, and the dates appear to be around those times. Yeah. The problem, Your Honor, is, as you know, with any criminal history, often the arrest shows up, the disposition shows up, and something else shows up, and it looks like there's 3 separate incidents on 3 separate dates when it's all one incident. So I would like the opportunity, of course, to look at this. But basically, based on the fact that there is less candor with the court, that's not a reason to go ahead and now strike this juror for cause based on telling us about a misdemeanor he'd had for fighting and then not telling us about a few others, if that's what the case is. And we don't even know if that's the case. So we ask that you deny the motion for cause based on that. Obviously, the defense, just like the state, has the opportunity to use a peremptory strike on juror 140.
Okay.
Your Honor, from my limited experience, which is somewhat dated from the prosecutor's perspective, New York criminal histories can be sketchy. It's hard to decipher. I thought it was a felony. Coming in this morning, I was told it was a misdemeanor. I would defer to McMichaels and the state on that, but I think that's something we certainly want to concur on. It would be a shame in Georgia, unlike some states, if you have a convicted felon on the jury, that's not harmless error.
And I can add to that too. What we also found was a local news article in the Brunswick News reporting that juror 140 was, I don't think he was arrested, but the article referred to a felony conviction. Of course, we're not relying on a newspaper article to establish that, but it was here in Brunswick not that long ago, and it involved the pulling of a gun on a person at an apartment swimming pool by juror 140, and the police were called out, and the newspaper, of course, as we've well established, media doesn't always get the facts right, reported that he had a felony. That's what set us off to search for this. And again, it doesn't appear that there's a felony on the New York record, but that's how the trail got started.
All right, let's get the information to the state, let the state review the information. We're going to be reconvening here in about 15 minutes. What time is it now? It's 10 past, no, quarter past. So let's go, plan on 10:30. If I could see council in the back, just so that we can update everybody on where we are with the panel.
Would that be now or at 10:30? Is that before or after?
That's now.
Okay.
Yeah, thank you.
really need it, do I? All right, we're back on. All the defendants present, represented by counsel. We have a full panel and panel one available. I'd like to start moving towards jury selection. Let's follow up on a couple matters that were before the court then. Has the state an opportunity to look at the information the defendants were able to discover with regard to juror 140?
Yes, Your Honor, the state was. We had actually pulled Juror 140's GCIC. They, of course, cannot transmit it to us, so we had to have someone read it to us. It appears that everything in New York, when someone is sentenced to, quote-unquote, 1 year, the sentence is actually 364 days. So the defense was correct in their analysis of all of these charges that he had. He had numerous charges. The case from Brunswick, where he was, I think, indicted for some charges regarding the pool situation and possession of a firearm by a convicted felon, those charges were null prost here. And I will state in my place that it is often a case is indicted or accused with that, and then the actual certified copy of conviction comes into the district attorney's office. It turns out, oh, this 1 year doesn't really mean 1 year, it means 364 days, such as in New York. So the assumption by everyone, and I believe defense counsel's investigator looked into this in the clerk's office, is that also is a misdemeanor and those charges were dismissed. So it appears 140 is not a convicted felon from what the state can tell at this time. And the other consideration that I talked to defense counsel about is that he did indicate that his brother had this gun charge out of New York. Sometimes brothers will use their brothers' names when they're arrested, and there's no way for us to know unless we ask this juror, you know, when your brother got the gun charge, was it on your record, meaning did he use your name? And that's just something I thought of because he was talked about his brother having this gun charge in New York City, and that may have been something there. However, I think that's it. Anything else, gentlemen?
It's just, for us, Your Honor, it's an issue of candor. It's an issue of answering questions. Have you ever been arrested or charged anything? And the answer was yes, up in New York some time ago. As it turns out, it's multiple things, multiple convictions, and a new arrest here in Brunswick, which he did not disclose. And when you're asking jurors to take an oath, and they do so, and they're asked to be truthful and give honest answers, this juror was dishonest. And I think we've now established that beyond a preponderance. And we'd ask you to strike him for cause.
All right. I hadn't pulled 140. I pulled 219. Oh, hold on a second. Let me pull my notes on 140 and just take a look. I meant to do that, but only got to 219. He's on the first panel. I'll let counsel know whether he's available or not. once the court's had an opportunity to look back through those notes, just so that we're clear about where we are with selection. The court looked at 219. This is this undisclosed social media account. And I weighed back and forth about what to do with this. One option to the court is to bring that juror back in for additional questioning. My concern with that is it just opens, there's a lot of different ways that can be interpreted by the juror, and I'm struggling with whether or not that's what I need to do here. Because of that, and because I haven't decided that's the appropriate route, I went back and looked at the notes that I have from this juror, because the issue is candor, as I understand it. I mean, these TikTok accounts are known to all now, so the idea is candor, and whether or not there would be more information, or whether or not at the time that she was being examined on Thursday the 21st, whether there was any indication that there might be more there that she was not disclosing. And looking back through my notes, what I have for the notes, I mean, she recognized Mr. Bryant, knew his wife and kids were in choir together, got all her info that she had on the sheets from news, written stories, online early. She's never able to watch the full video. She talked about her opinion that she had pondered guilt or innocence. The whole back and forth about can you set that aside, talked about the burden, consider legal defenses. She indicated she was one of these individuals that did want to sit, but that's because that she was called and should do her duty. She was asked about negative feelings, talked about the sanctity of life, particularly the young, can still be fair and impartial. Talked about race. Mr. Sheffield then spoke with her. And my notes here is that he went through with her the duty that falls upon her as a juror. Talked about race. Explained how race may or may not affect her decision process. Talked about how her decisions, again, were based on the media. Talked about presumptions of innocence. What would happen if she was presented with facts. And based on, it looks like she was extensively questioned. And so the court's not inclined to reopen questioning on this. Again, the information on her TikTok account, I will point out, and maybe this is just a generational thing, but when we start talking about TikTok accounts and dance videos, I did not expect that from the demographic represented by this juror, which I have as a white female, probably in her mid-50s. I was a little surprised by that. My kids maybe would understand TikTok much better than I. Maybe they would understand that, but it just shows you generationally where things go. But so the bottom line is the court's not going to reopen 219. The court's explained why, and we'll proceed with 219 on the panel.
Your Honor, has the court reviewed the TikTok videos in question?
I've not reviewed the TikTok videos in question. No one presented them to me as part of the evidence in the motion.
Sorry?
They were not presented to the court. It may not be a surprise, or maybe it will be, but I do not have a TikTok account that I'm just jumping on to go ahead and look at videos.
I don't have one either, Your Honor, but respectfully, we object to not being allowed to ordeer her on information that was not disclosed and came to light after she had already been examined.
They were not submitted to the court. So the court did not have an opportunity. I can only go upon the representations of counsel, and we've had an ample opportunity with this individual now to examine the facts and circumstances that may surround her as a juror.
Well, Your Honor, then for technical reasons, we'd ask for a continuance so that we can find out how you download TikTok videos and put them on a drive and submit them to the court, or the court can allow us to perfect the record later. But I only got this information last night. I mean, you know, in the evening, it's practically impossible. The only reason I can do Facebook is because I've been doing it, but I don't know any. I have the same problem the court's got with TikTok.
It's fine, 219. I will give you a limited opportunity to ask her specifically about the TikTok videos.
Thank you, Your Honor.
Judge, may I inquire? Did the court state already in its decision about this that she was asked about social media on forms and did not disclose this account. Is that what Mr. Hall, that's what, that she did not disclose it?
Your Honor, while we have a moment, one other issue is juror number 52, summons number 52, listed as number 4 on panel 1. This was the juror who had contacted the court, and you were going to look into that?
No, I looked at the note. We have had no subsequent contact from her or any indication that there's any continuing problem. And so the court's not going to reopen that on 52. That was early on in the process. That was when information was being pushed out. And I have not received anything further, nor has the clerk nor the sheriff, from my understanding.
Well, yes, just to perfect the record while we're still waiting for the juror, I have to go back, there's so many papers here. I don't believe we moved for cause on her at the time, because we didn't know what was going to happen, obviously. I'll double check, but in the event that we would move for cause for her now based on her concerns that she expressed after this information had been provided to the public. It obviously appears to change her perspective about how her own security and safety might be affected by sitting on this jury.
Ms. Goff, I assume you join that?
Yes, yes.
Or at the very least, we would ask to re-question her.
From the state.
Thank you, Judge. People are often upset in the moment, and it appears she was upset in the moment and reached out and called the court. There's been no further contact with her at all regarding this issue. There's been no follow-up, and she's been here today, and I'm assuming no note has been sent to you, the clerk, or anyone else about this issue by her. So at this time, we ask that we don't reopen the door to this. We understand her concern in the moment, but that concern in the moment does not necessarily translate into a concern about serving on the jury, and we ask that you deny the motion to strike 52.
And let me put on the record, too, because I don't want the note to be misinterpreted. I simply received a note. I think there was a comment yesterday, and I tried to correct it about her freaking out. That's not the reason that I got that. I received a note from the clerk that we had received contact from juror 52. Just to be clear, and I just realized as we're going through this, that the way we've been doing this is I've been releasing the remaining potential jurors in the courtroom, and those that are being, well, no, she would have gotten the instructions here. So the instructions she got here, actually on the record before the parties, was don't talk to anybody, don't let anybody talk to you, and if anybody contacts you, please report that to the court, and the court will determine whether there's some follow-up that's necessary. So she was actually given that instruction. So I mean, the note in some ways may even be consistent with the instructions given to the court. I've had no follow-up contact from juror number 52. There's been no additional issues brought to the court's attention, and she appeared and has not made any comment about that note or any further contact to the court. So I just want to make sure that was on the record, too. I'm not sure that was a renewal or what it was, but again, the court satisfied that that impaneled juror. The note was just reflective of a concern that she had that she brought to the court's attention appropriately and was addressed, because I have not heard any further information from her.
For preservation of the record, we did move for cause, and that's been denied, and we've moved to re-question her, and that's been denied.
Yes, thank you.
Your Honor, we're looking for the original, well, clerk doesn't have the original juror questionnaire for 219. I have a copy. Do you have a copy? I have a copy of the first page. I need the copy of the full page, for the full questionnaire. Now, the questionnaire itself is already made part of the record by the court's ruling this morning.
Correct. I just want to make sure you got something to work off of.
Yes.
Okay. 219.
Okay. So, and I just want to point out, as she's walking out, she's shaking her head. She's frustrated. Okay. I'm gonna strike 219, but let me explain why. These individuals that came in for jury selection went through a long and arduous process. You can go ahead and sit down because I'm striking. Long and arduous process with state questions, defense questions. And I mentioned a couple times on the record while we were doing this that I think parties need to be very careful about what we're doing here because some of it can start alienating people. Some of it can really start pushing people's buttons. And when I was talking about Juror 219 before we got started here, one of my concerns was bringing her back in and what effect that may have. And I'm watching that, and I in good conscience, I can't put her back on the panel. She went through 45 minutes back on Thursday, and we're just on Mr. Goff. The state's going to try to rehabilitate her. I'm sure there's going to be questions from the McMichaels. We're going through another half hour with this juror. And I could tell just from the way she was reacting to this that she's starting to get very worn down by it. And again, I wanted to point out as she was walking out, the fact that she's shaking her head and frustrated. That's the reason that I brought up the concern before we started. And I'm not going to put a person back on the panel that's going through that type of thing again and again and again. So she's going to be struck based on the court's concern at this point that the process itself has put us in a position where I'm worried, candidly, that she's frustrated with the defense, simply based on what we've been doing here. And again, I've raised that before in jury selection, so that shouldn't be new to folks. That's going to be the ruling of the court. We're not going to go any further with that particular juror.
Your Honor, the state has a request that this be one of the defense's peremptory strikes. The state looks at this as if they basically came in here and cross-examined her, and Mr. Bryan basically said, I'm not questioning this, I'm questioning your ability to do this. And now he gets a free pass. We get this juror off because of Mr. Goff cross-examining this juror, and the state is put in the position now of having to go ahead and do all of our strikes. So the state is just as frustrated that they have managed now to get this juror struck for cause because of their behavior with this. And I understand the court's ruling. It's just the state feels it should be one of their peremptory strikes. Thank you.
No, I'm not going to do that here. No, but this is exactly what I was talking about on the record prior to this. So we're not going to engage in this over and over again. I've stated the court's position.
Given the court's rulings, I will give Ms. Dunkowski the last word.
We have a number of people that are waiting to move through the panel system for jury selection. I believe we're there. I am going to, unless I hear an objection, go ahead and address the three panels that have been waiting, just to let them know that we're thinking of them and we're moving this process along. And appreciate their time and commitment to the process. Anything from the state?
No, Your Honor, nothing from the state.
From Travis McMichael?
No, Your Honor.
From Greg McMichael?
No, Your Honor, except a question. You did have a couple you were still thinking about that you're going to let us know before we go.
They're all available.
Pardon me?
They're available.
All of the ones we were talking about?
Yes.
Oh, in panel one, is that what you mean, Your Honor?
Panel one is, and then
I think in panel two, we had one who was at home.
the note I have is for the day. So not available today.
To be present today, but
To be
is in
present
play.
today, I have, yes.
Okay, that's what we need to know.
Yep. So other than the one on the second panel that I've already indicated will not be available, that's juror 558, that second panel is intact, and the third panel is intact.
And again, just to clarify, that means that 276 has moved up into the main panel, and now in light of the 219 cause strike, 281 moves up into the main panel?
From a number standpoint, yes. If reached. All right. I'm going to go ahead and address the panels, and then I'm going to ask everybody to go ahead and transition into the jury assembly room. We'll get started.
Your Honor, we're still asking for time to confer.
We are now at 11:35. The court has not been in session all morning. In fact, I think I've only really been in session for maybe 45 minutes. And I realize we've had some meetings in the back. But at this point, I've had a number of people that have been waiting patiently, who I'm going to go ahead and address, and I'd like to get started with jury selection. It's going to take a little bit of time to transition. The request was for an additional 60 minutes. The court's not granting an additional 60 minutes to confer. We've been doing this for 2.5 weeks. We've been moving through these panels deliberately, and has been a significant amount of time. This should be is no surprise to anybody that we are going to try to pick a jury this morning. So we're going to try to pick a jury this morning.
For the record, I'm preserving for the record my request pursuant to the statute. I think under the circumstances of the case, additional time is authorized. I would respectfully and humbly submit to the court that it would be an abuse of discretion not to provide counsel at least 30 minutes, having just figured out who several of the jurors are, and I believe the state is expressing frustration that they too have to go back through these same lists, and especially because they have to exercise their strikes first. But my job isn't to protect the state. My job is to protect Roddy Bryant. We put that on the record.
Court notes time as I think I've got 11. What do we have? Can't see the clock.
11:37.
11:37. All right, thank you.
One moment, all council's not present, I'm not sure.
Who are we missing?
Council's
Okay. Just bear with us for a second. Apparently, we've lost a lawyer in the courthouse. I heard that. Yeah. Yeah. Yeah, sorry. And then just to be clear, normally we're better at coordinating this. That's on the court for a little bit of a delay, or not a delay, I guess, the logistics.
Thank you, Your Honor.
All right, ladies and gentlemen, welcome back. Many of you we have not seen in a little while. And when last I saw you, I indicated that you were potential jurors or remained potential jurors in this case. The part of the process that we're now moving into is, at least from a jury selection standpoint, the final part of the process. What's going to occur today is that we are going to narrow the pool of potential jurors into a trial jury. Now, this is a silent process, and so what you're going to see is paperwork going back and forth between the state and the defense and the court. And what is actually occurring is it's a deselection process. What occurs is certain members of the panel are struck, not because you're not good people, not because there's anything wrong with you, but just because based on the way we do this, decisions have been made on whether or not the parties in the court believe that you're the right juror for this case. So that's the process. Again, it's a silent process, and so you're not actually going to have to be actively engaged in it. You're here because we need to sort of remind ourselves who everybody is and make sure that we have everybody in one place and the panel is intact in order to make sure the selection process can occur. So, welcome back. I do ask for your patience. We're just going to go ahead and move forward. It doesn't take that long. Normally, with a group this size, I'd imagine about 20 minutes or so, where you'll just see some paper moving back and forth, and then I'm going to give you some further instructions. Is the state ready to proceed?
Yes, Judge, the state is ready.
Is the defense ready to proceed?
We're ready. Yes, John.
All right, let's go ahead. When it doesn't get to me, it's a good thing.
approach quickly.
All right, ladies and gentlemen, it's amazing how quiet 70 people can be in a room. All right, so the way this process is going to move from here is we're going to go.
Is your microphone on?
Oh, we turn it off? Get it closer. Thank you. Can everybody hear me?
Yes, sir.
Okay. All right, so what we're going to do at this point is we're going to transition you all out of this room, and we're going to bring a different panel in. Given the time of day, I've told the other panels already we're going to do this. We're going to go ahead and get you something to eat so that you're not starving and don't have to leave the courthouse as we move through this process. I do ask again for your patience. I appreciate it. But we will continue the process of moving the panels through and hopefully be back with you relatively soon with an update on where we are in this process. So thank you. Thank you for your patience. Are we ready to transition them out? Who's taking them? Yeah, all right, ladies and gentlemen, we'll go ahead. We're going to adjourn this panel. If you could just follow the bailiff, and they'll give you instructions on where to go. Well, and I think what we're going to do. Yeah, don't leave with that. All right, ladies and gentlemen, let's just take a very short recess, 5-10 minutes at most, and then we'll bring the second panel in, and we'll start with the second panel. We're off. Well, Good afternoon, everybody. All right, can everybody hear me? All right, based on that response, I was concerned. All right, ladies and gentlemen, welcome back. I saw you all a little bit ago and just indicated we're moving forward, and I appreciate your patience. Let me tell you where we are in the process and what's about to occur. So when I released you, when you were in before, indicated you were potential members of the trial panel. What we're doing today is we're narrowing that group of potential jurors down into the trial jury. What's going to occur here in the courtroom is that the state and the defense, through a silent process, are going to go through a process of selecting the jury panel. You are not going to be participating. You're not going to be asked any questions. What's going to occur is I'm just going to ask that you just sit and be patient as we move the paperwork back and forth. That paperwork is what we use to keep track of everybody and make sure that we have the numbers that we need and so forth. The process, at least based on the last panel, it takes probably 25, 30 minutes just to work through that process. I ask for your patience. Once that deselection process is done, I'm going to move you back into the courtroom, and as I indicated, we're going to get you some lunch and make sure that you've got something so we don't have anybody falling out. So again, I ask that you bear with us. Again, this is a silent process, and once we have gone through this panel, I'll give you further instructions. Is the state ready to proceed?
Yes, Your Honor, the state is ready.
Defense ready to proceed?
Yes, Your Honor.
All right, let's go. Actually, that one is still available. No, but still available.
I understand.
Yeah.
Okay.
I'll-
Are the parties prepared to move forward with the last two members?
Yes, Judge, the state is.
All right, let's go ahead.
We're prepared.
All right, ladies and gentlemen. As far as this panel, we've gone ahead and done as I indicated, worked through the strikes. We have one more panel to get through, and so I'm going to ask is that you go ahead and adjourn here, and then we will give you further instructions once we have the final panel in place. So all of the instructions that I've given you previously are still in place. I'm going to ask that we move you back into, I think, one of the courtrooms, I believe. But if you could just follow the bailiff, and again, I'll give you further instructions. Thank you. we had gotten panel 3 some lunch, and so they're actually having some lunch. Why don't we go ahead and break for lunch, since they're doing the same. I do want to make sure everybody is clear on 579. That was not an oversight by anybody. 579, there was a medical issue, and I just want to make sure everybody was clear about it. I received a doctor's excuse for today.
Yeah, you said she was in play,
Correct.
right?
But that she was not here due to a medical issue, and at least what I had just said for the day. Now, whether that means it's any longer, I don't know. I guess we'll have to find out tomorrow. But as far as any instructions to the panel or anything else to the panel, that individual will not be receiving anything from the court today. So, just want to make sure everybody knows what they've done before we accept the panel.
Yes, Judge.
Okay. All right, we're going to recess. Let's do so. It's 1:20. I want to go until 2:15. That gives everybody an opportunity, including the balance of the panels, and then we'll reconvene here. Thank you.
Thank you, Judge.
Come to order, all right. The County Superior Court of County Session, I'll just Timothy Wamsley presiding. Please stand.
All right, good afternoon, everybody. I saw y'all a little while ago, told you we were moving in a very deliberate way, and hopefully you got something to eat and are ready to go. So let me explain where we are and what we're doing right now. When I released y'all a couple days ago for some of you and more recently for others, what I indicated to you that you were potential jurors in the case, or you remained as potential jurors in the case. What we're doing today is narrowing that group of potential jurors down into the trial panel. And that's being done in groups. This is another one of the groups that is coming through. What's going to occur today is the state and the defense, along with the court, are going to go through what we describe as a silent strike process. What's going to occur is there's going to be some paperwork that goes back and forth between the state and the defense and the court. And that paperwork assists us in determining ultimately who is going to be selected for the panel. If we can make sure our phones are off back there, please.
Your Honor, my apologies, but may I approach?
Yeah.
All right, we've worked it out. Thank you. Thank you, Your Honor.
It's always great when things get worked out without the court's intervention.
I know you like that.
I appreciate that. All right. So what we're going to be doing is there's a process where some paperwork will be going back and forth. It's a silent process. Normally takes, for a group this size, about 20 minutes or so, maybe a little bit longer. But once that process is complete, what we're going to do in this particular case is we'll move you back out, and we're very close to actually impaneling a jury. So you'll get further instructions once that entire process is done. So if you could just please bear with us. Again, I thank you for being here, just like before, and I thank you for your patience, just like before. I believe we are ready to proceed. Is the state ready?
Yes, Judge, the state is ready.
Defense ready? Yes, Judge. All right, let's go ahead. Rachel, do I need to mark yours? Oh, it's when you're passing around, yeah. Yeah. Let's get it from Liddell.
Do you have the seating chart down there?
I may have one moment, Your Honor. Thank you, Your Honor.
Thank you. I assume the suggestion was to just exercise what needs to be exercised?
Yes, Your Honor.
Yeah. The state doesn't have any objection to proceeding that way?
No, no objection, Your
All
Honor.
right. If the defense could just go ahead and complete the sheet. Okay. No, we're good. We're good. Thank you. We're good. All right, ladies and gentlemen.
Your Honor,
Think-
I apologize. I have no idea what happened on the rest of the page.
Oh, you haven't seen it?
No, they haven't shown it to me.
I'm sorry. Liddell, if you could just give that to the state, just let them take a look at it.
Thank you, Judge.
My apologies.
Thank you, Your Honor.
All right, sorry about that. We got ahead of you for a moment there. All right, ladies and gentlemen, we've gone ahead and moved the process, or through the process, the way I indicated we would here. I think, are we keeping them in here? Okay, we're going to have you remain here, but in order to do that, I'm just going to ask that we take a brief recess. Why don't you go ahead and just step out for about 10 minutes, and then come back on into this jury assembly room, and we'll be getting back with you relatively quickly, I would think, with some additional instructions. Okay? We'll go ahead and take a 10-minute recess. Again, all of the instructions I've given you, don't discuss the case amongst yourselves, don't go looking for any information about the case, and don't let anybody approach you about the case. All still apply. Thank you.
All right, we're on. Defendants are present, represented by counsel. Understand the state is in motion.
Yes, Your Honor, at this time, the state does the reverse Batson motion called McCullum motion. And at this time, as the court is aware, based on Hogan versus the state, which is 308 Georgia 155, recent 2020 case from the Supreme Court of Georgia, there are 3 steps to this particular process. With any such Batson or McCullum challenge, the first step is on the state to make a prima facie showing that the defense struck these jurors, and in this case we're talking about the 11 African American jurors, because of racial bias. And in this case, the prima facie step for the state is to do the math. In this case, we had 48 jurors to select from. The defense was given 24 strikes. The state was given 12 strikes. And in this case, we had 12 African American jurors. We had 36 white jurors. So African American jurors made up 1/4 of the jury panel. But the actual jury that was selected has only 1 African American male on it. It has 11 white people on it. The state exercised all 12 of its strikes, yes, for white jurors, but the defense, having 24 of the strikes, double the number of the state, they exercised 13 strikes against white jurors and 11 of the strikes against the African American jurors, seating only 1 African American juror on this panel. We ask the court to find that the state has made its prima facie showing of racial discrimination based on the math for this case.
All right, we don't need to get into step 2 at this point, but anything from the defendants on 1. This is the first step as far as the state's prima facie case.
Yes, Your Honor, I don't think those numbers bear out a prima facie case. I think this is a situation where each of these jurors are going to have to be taken one by one for the state to be able to argue that the strike was racially motivated. Because in this instance, given the numbers, there were 50 qualified jurors. 23 of them were white females, 13 of them were white males, leaving only 12 black individuals, 6 black females and 6 black males. So for the main panel, that's what we were dealing with. With the alternate panel, there were no strikes of African Americans by the defense team, so I'm assuming that the numbers we need to look at are just the main panel. And those numbers don't bear out a prima facie case of some intent in selection procedures. And in fact, I will state that we have a very clear selection procedure within the defense team, and the issue of race is not one of the factors. I can address the issue of the race-neutral reasons for every single one of these, but that's...
Court needs to make a finding first.
Yes, thank you.
Mr. Bryan.
Your Honor, all I can say is we can't address the specific strikes, but that was my understanding. There was a hierarchy being used, and none of that had anything to do with race.
Again, this is a 3-step process. Everybody's familiar with it. Reverse Batson McCollum, however we want to define it. The first step that the court needs to engage in is the analysis, which is really just a numbers analysis and then a view of the panel in order to work through the prima facie side of it. The court does find that the first step has been satisfied by the state. Given the numbers involved, the pool itself, and I've got the same numbers. I had for the 48 in the first 2 panels, 12 black jurors, 36 white. Half of the defense used, I had, 11. So 10 or 11 strikes. Either way, a disproportionate number on the black members of the panel. court finds in this particular case, the state again has satisfied its burden with regard to a McCollum or reverse Batson. The individuals then from the state that are challenged, I assume would be, and I have down summons number 140, 143, 218. I'm sorry?
Will you say that again where you just started?
I started, I'm just going through what I have on the list. Maybe the better thing to do is have the state list out what it believes were the individuals that were improperly removed from the panel with preemptory strikes.
Yes, Your Honor. At this time, we have our 11 jurors. Juror 140, Juror 143, Juror 218, Juror 253, Juror 386, Juror 395, Juror 403, Juror 414, Juror 479, Juror 119, and Juror 209.
And just to make sure, if I can inquire, Your Honor, is the state moving that every single one of these jurors, in their opinion, has been struck solely based on race? That's the opinion of the state, that every single one of these jurors has been struck solely on race? We have to go through all 11?
I'm sorry, I was just putting the 11 who were the African-American jurors. If the court wishes me to specify,
That would probably narrow the process down, yes.
right. So now, for the state is going to challenge at this time Juror 143, 218, 253, 386, 395, 199, and 209. Hold on.
119.
Did I say 119?
I think the state said
I
119.
meant 199 and 209.
Okay. The jurors then, I understand, are before the court would be 143, 218, 253, 386, 395, 199, and 209.
And I missed one, Your Honor, which was 414. And then that would be correct, Your Honor.
Okay. All right, to the defense. Let's do one at a time then. I'm not sure who's going to be handling these. Okay. So what I'll do is, let's just start. I'll call the number out and we'll walk through it from there.
And just so the court understands, Ms. Hogue is going to be responding on behalf of Travis McMichael as well as Greg. If we feel anything's been left out, we'll rise, but I don't think we will.
All right.
Likewise, Your Honor.
All right. Juror 143.
One moment, Your Honor. If the court would allow, may I do them in a different order, but if you give me 2 minutes, I can do them in your order. I had them by strike, so one moment. And Your Honor, because we move the panels around, that's where it gets a little, we have to combine our different notes. So with the court's permission, I'm going to begin with 218, may I? And we'll come back to 143.
I'm clear on where we are, because ultimately I'm going to have to pull my notes.
All right, thank you.
218.
All right. Juror number 218, Your Honor, was on panel 6. And that juror raised her hand to say she could not be, she had formed and expressed an opinion. And that opinion was, I feel like they're guilty. In her juror questionnaire, she said a young man was shot due to his color, and the 3 men that committed the act almost got away with it. Almost got away, excuse me. She raised her hand to say that she was biased against one side, and she raised her hand to say that she had a negative of feelings about all 3 defendants. She said that the only thing that would change that negative opinion from fixed to changeable was to depending on what I hear in the courtroom. She said later on that she believed that asked about the opinion that yes, I have formed it. I feel like they're guilty based on the video and based on the media. And that the things that were subject to changing that would be what she heard in the courtroom, which we attempted, to consider some questions that had been previously objected to about trying to develop that as a burden shifting, but that's really nothing but a burden shifting. And then during the questioning, one second. She stated, I believe he was shot because of his color. She was asked, what made you think that? And she said, I had heard that they called 911, and 911 told them to just leave him alone, but they still went after him and taunted him and shot him. I heard that on a YouTube video. She also indicated the support that she'd done for the Run with Ahmaud or Justice for Ahmaud cause. I did a bike ride for Ahmaud to raise money, I think, for a lawyer or the family. Then speakers came in and they talked about Justice for Ahmaud. She was asked why you wanted to join the ride, and she said, I wanted to ride for his death, to support the family. Given your support for Ahmaud's family, do you think you could really be fair to the McMichaels? And I use an ellipses, I think like the court does when there's an extremely long pause, and the answer was, I think I could. She had a very favorable view of Ahmaud, she volunteered, and was asked about that, and she said, well, given the way that he died. She was questioned about her having indicated that she believes that black and white people are not treated equally by the police, and asked how she feels race plays into this case. And she immediately went to this feeling. I feel like sometimes we don't belong in some areas, and that's why police take actions, as if we're in the wrong place or in the wrong cars. I feel that Travis shot Ahmaud Arbery because of race, because he was where he was at in that neighborhood. Asking again, given your life experiences and opinions, do you think you're the right juror for a case like this? I think so, but then she said, the answers that I've given, I don't know. And she was asked, sounds as if you're expressing some doubt. Can you dig deep? And she said, asked if you could be fair and open, and she said, I like to stand on the side of right, meaning she has a very aspirational sense of what she should be answering and how she should be feeling. For that reason, Your Honor, this juror was a completely appropriate peremptory strike. And as we're going through each of these jurors, and these are race-neutral reasons, I will say that most of the jury selection in this case and the decisions we had to make is the epitome of the lesser of two evils. We are stuck between a rock and a hard place, given the fact that the majority of the African American jurors that came in here were struck for cause immediately because of their firm opinions. Later on, we had some African American jurors whose opinions were very strong, but they indicated that they could put them in a box and set them aside. So it's up to us to use our peremptory strikes to say to ourselves, is that the kind of juror, given those impressions and feelings weeks ago when they filled out the questionnaire and still fixed on those opinions today, would you want that juror judging you in this case? And the answer is a resounding no.
I think the better way to do this is let's go through each one, see if what the state's response is based on the explanation of the strike from the defendants, and that may be a way to pull this together.
You want the response, or you want
No, I was saying let's get through these, just trying to figure out the most efficient way of doing this so that I can keep it in order.
Yes. Your Honor, I'm going to address juror number 143.
And let me just make sure, if the state follows it that way, or would the state prefer to just address each one in turn? I'm either way on it.
I think it's going to be hard for me to then start back after listening to everything they said. I'd like to do it.
Let's just go back and forth. That's fine then. 218 from the state.
Thank you, Judge. So, Judge, the problem with the defense's argument here is simply that the jurors weren't asked for an opinion on the questionnaire. They were asked, what do you believe the facts of this case to be? And every single juror came in here having written down what they believed the facts to be, and they all told us they got that off of the news media, social media, and of course we pointed out, well, that's often wrong. It doesn't have all the evidence in the case. And are you willing to listen to the evidence in the case? She indicated she would. She also indicated she was very nervous about being here. She has a job that she's been at for 15 to 20 years and actually knew Mr. Goff from that position. So in this case, there is absolutely nothing that the defense has done but list out all of the things she just said. Okay? And we all know that that's what she said, but they failed to provide any sort of reason to strike her that she's different than any other juror who came in here stating facts that they had heard from the news media and TV, saying they had formed an opinion based on those facts from the news media and TV, and then, of course, said, well, I formed an opinion. Now, the quintessential question isn't whether you formed an opinion. Numerous people came in here and said, yes, I formed an opinion. It's guilty. But the real question here was, can you put that aside? Can you put that opinion aside? Because it's been based on news media, the video. It's been based on the opinions on social media, not on the evidence within these four walls. And in this case, this juror did indicate she could do that. She was open to all alternatives and facts in the case. And despite her opinions about numerous issues, she said she could give the defendants a fair trial in this case. So right now, the state doesn't see that the defense has given any reason for striking her, because she said the same thing just about every other juror who came in here said about being able to put it aside, being able to be fair and impartial to the defendants in this case, and to give them a fair trial. She indicated that, I want to find it correctly, yes, she indicated that she could be fair and impartial, that other people had expressed their opinions to her, but that's not her opinion, that she was able to weigh things herself. So we ask that you find that this litany of these are the things she said doesn't really show that there's a race-neutral reason for striking her. The state's position is that she was struck because she is an African-American female, not because she's any different than any other juror who came in. She is no different than any other juror who came in here having information about the case, an opinion about the case, and said they could set it aside. Thank you.
Your Honor, point of order, that is not an appropriate response to a Batson challenge. That is not the third step. That is the response had we made a motion for cause. And for Ms. Donikoski to point out how that juror had indicated that she could sit for the jury. What is incumbent upon the state, once the defense has provided race-neutral reasons, and all of those are overwhelmingly race-neutral, is for the state to try to show to the court why those reasons are not accurate or not race-neutral. That's all that the court can show in order to unseat or to undo the strike that we've made. For the state to be able to say, hey, look, here's why we think that's not accurate what you just said, or that's a cover for race. And in this instance, there will be no evidence of that, or if there is, the state certainly has not provided that. The classic example is this, Your Honor.
Let me just expand. The ultimate burden still rests on the move-ant. The state is entitled to respond. The genuineness of the proposed reason is part of the evaluation the court has to make. In fact, the genuineness might be as important as the reasonableness. And in this particular case where I have eight separate individuals we're going to be discussing and 11 individuals total of this particular class, I do think that it's appropriate to hear from the state on what we've done with these individuals and how we've reached them, qualified them, and gotten them here, and compare that to other individuals that ended up on the panel that did not get struck. I don't really understand the defense objection.
Now, I think what the burden is for the state to say, you relied on a factor that you want to act like is race neutral, but when that factor was present in other individuals on the panel who were not of the same race or ethnicity, you didn't care. So if I were to say, for example, I'm striking juror number 2 because he has dreads. Well, that would be ridiculous. That's obviously not race neutral. But I might say, well, I don't like that kind of hairstyle. You know, my client had some issue with that kind of hairstyle. And I might have left a white juror on with dreads. And then the state could say, I'm calling you on that. That can't be the reason. Or, for example, I'm striking juror number 22 because he was late, and juror number 22 was a black male, and the state would then say, hey, you know what? There were 4 white males or females who were late too, and you didn't seem to care. So it wasn't honest that that was the reason you struck that person. It can only be disingenuous challenge or that the reason I gave was not race neutral.
Why do I feel like we may have just said the same thing? Because what I'm relying on is Davis. Talks about genuineness of the response versus reasonableness. So I think we just said the same thing. I'm not quite sure what specifically are you claiming the state is doing?
The state's response is essentially non-responsive to the McCullum challenge. To say to the court, this juror said they could be fair after we questioned them, is all that they've said. So that's not helpful to the court in the challenge under what the law requires for the state to rebut. There's a lot of jurors that came through here that said they could be fair. We had given race-neutral reasons because of the opinions, not just facts, but the opinions of this juror, as were expressed by a lot of other white jurors who were struck, who we moved for cause on. The people that we've seated, we believe, came to court and did not hold such strong opinions. So the state needs to come back to the court and say, not this juror can be fair, because they said they could be fair. They need to come back and say, they're not telling you the truth, Judge. They're using these answers as a cover. And the only way you can assess that is to comparison to other jurors. I don't think that you can just repeat that the juror said they could be fair.
That's what I heard the state finish with, which was went through what this juror had said and then said when compared to those answers when compared to white jurors are the same. That's what I heard from the argument.
I think the answer would be when compared to a juror that they sat one of these people that's an actual juror, when compared to that one that they were not on. You think we're on the same page?
I think we're on the same page. I mean, I understand,
Okay.
Yes,
I feel like we're saying the same thing. I heard the state's argument.
All right.
Yeah, I understand what the burden is.
If I may. I feel like I'm in the twilight zone. When I hear a juror that arguably could have been excused for cause because of a personal investment in the case. I mean, I've never been in a trial where...
That's what we're trying to avoid, is getting back into strikes for cause.
Right. But while we're questioning the truthfulness of the reasons that are stated here, I mean, I just don't understand how the state in good faith, in this situation, in a case where a juror could have been excused for, could arguably have been excused for cause, how we could go from that juror possibly being excused for cause to a point where they couldn't legally be stricken? In what free country would a juror who went on a bike ride to raise money for the opposing side's legal team, how that person could be, the defendant could not strike them for that reason, and that reason alone? That's Kafkaesque, and I'm just suggesting that this process would be a whole lot simpler if the state would take a moment and further consider the jurors they're asking about and pick the ones where there's a genuine issue instead of playing to the cheap seats, rather than Your Honor.
We're not headed in that direction, Your Honor. We just felt the state's answer was non-responsive to the court's inquiry.
I think we're on the same page here. I'd just like to move through it.
So the next
So the next
sounds
one.
as if we can do 143 now.
143. Mr. Rubin.
Your Honor, 143 is a juror that actually generated a lot of discussion among the McMichael defense team. Initially, we liked him a lot. We thought he could be a fair and impartial juror based on the answers he gave in court. The problem is what we found out about juror 143 outside of court. Juror 143 told us that he was getting married next weekend and could serve despite the marriage, that he wasn't taking care of any part of it. I think his fiancée was doing everything. When we looked at his fiancée's social media, we found that she was a strong supporter of the Justice for Ahmaud movement. Her, and I might say this wrong, but her face page of her Facebook page, I'm not sure the right word for that, but the initial thing you see is a close-up of her
I
face.
object. At this point in time, that's not before this court. There's absolutely no evidence. This is Mr. Rubin stating in his place that he looked at somebody's Facebook page and found some other stuff. That is not evidence before this court. That is not what that juror said, and I object to this.
It's sustained. If they said it during voir dire, that's fine. If it was discussed and identified, that's fine. But let's not talk about something that wasn't actually brought up in voir dire.
Well, the whole point of why we struck juror 143 and didn't seat him is not because of what he said in court or did say. It's because of what we found out about him. For instance, he told the court and told us that he resigned from, let's find my notes, resigned from being a police officer with the College of Coastal Georgia. In fact, his certification was revoked. We have his post records. He was not honest about
Objection, once again. These records are not before this court. That's not in evidence, and he wasn't questioned about
I'm
that.
happy to introduce those.
Well,
But we're explaining to the court the race-neutral reasons for striking this juror. Of course they're not in evidence. We didn't know he would be challenged under McGowan.
If we're going to reference them, they need to be part of the record. So let's figure out how to make them part of the record.
I just need to know how to print out what we have, and we can do that. And I can show Ms. Donikoski what we have and print them later.
Well, my concern truly here, Judge, is I have no opportunity to talk to this juror about these things and to explore these things. So I'm being ambushed. If I had been...
So I think in a McComb challenge, I mean, what I'm supposed to be hearing is the race-neutral reason. That's what's being described right now. part of the evaluation the court then needs to make is the genuineness, I don't like truthfulness in a McCollum challenge, but the genuineness of the what has been represented to the court. We are not limited to what was said in voir dire, but we're limited to what the actual basis was, or we are not limited, I guess, to voir dire. The court simply needs to know what the basis was. If that had to do with something that was disclosed in voir dire, or whether that's any other information that was used, the reason has to be presented, and the court then make the determination of genuineness and whether it's a reasonable explanation. So I'm going to permit it as long as the state has an opportunity to understand what we're talking about.
Absolutely.
Thank you,
And I'm
Judge.
happy to show the state what I have. I'm merely providing the court with the information we have so the court can understand our thinking in striking this juror, which is what my obligation is.
And for the record, I object to the characterization of any defense counsel in this case as ambushing anyone under these circumstances. That's jury selection 101.
Let's back up, because we're at that point in the trial, it seems, where everyone's nerves are a little frayed. You all have heard from me before.
Yeah.
This does not go back and forth between counsel.
No, I'm not.
Let me just finish. I just want to make, so any reference, I assume, is just a passing reference. Let's just go ahead and direct it to the court. I believe everybody here has acted very professionally, and I'm more than happy to hear the arguments. I don't see this as a personal attack.
And I don't take it as that. And I'm not judging the state at all. It didn't come from me. So the reasons for our striking juror 143, number one, is the cover sheet, whatever that's actually called, of cover photo of her Facebook page, which is replete with "I run with Maud" and script of Ahmaud Arbery all around her face on her Facebook page. That's number one, and that's not something we knew or knew to question the juror about. Number two is his post records, which are disturbing, actually, in their findings. Not only did he not tell us that his certification was revoked, but he was disciplined 3 times for dishonesty. According to the post records, he was disciplined in June of 2011 for falsifying time records. He was disciplined in September of 2012 for job abandonment. And then the case under consideration that's attached to the post records is a 2013 case in which this officer, or former officer, was under investigation for theft of time. He was working and getting paid for his second job while he was being paid by the college, I assume, for his primary job as a police officer for the college. So we have 2 of these 3 cases appear to be for dishonesty, none of which he disclosed when talked about why he was no longer working for the College of Coastal Georgia. Those are race-neutral reasons, and reasons that disturbed us in determining the honesty and the candor of this juror as he was being subjected or submitted himself to voir dire. Juror 291, who was struck this morning by the state, was struck for exactly the same reason, which is that the state found out and candidly told us about it this morning that juror 291's boyfriend, not the juror herself, but her boyfriend, was seen in a photograph wearing, I understand it to be a Confederate flag on a t-shirt he was wearing, or something of that sort, based on what the state told us this morning. Same race-neutral reason. We have no problem for the state striking that juror for that. That's up to the state. Same reason, not based on race, not subject to a McCollum challenge. And I'm sorry, I do need to show Ms. Dunikoski what I was just referencing. We're sharing the information with the state, our investigator to their investigator. Your Honor, while the state's doing its research, if I could just add to that about 143, that juror in his investigation by post authorities denied that he was working 2 jobs at the same time, getting paid for both, and they found that he, in fact, did receive compensation for the 2nd job while working.
One moment, Your Honor. Your Honor, if I may add something. It is what it is. Your Honor, my recollection of Juror 143 is that there was an extended colloquy between the juror and myself as to the many members of his family that I might be familiar with from other cases, both as a public defender and as a prosecutor. And I recall, and maybe I'm wrong, maybe it wasn't this juror, but I thought it was this juror, where my asking someone whether they knew me and whether we had dealings before was somehow a question of ego. Subsequently, I went back and consulted with another former colleague, and my understanding is that approximately 24 individuals with the same last name, all believed to be related to this juror, had dealings with my office. When he's saying he doesn't know me or anything about me, I don't believe him. And that is a race-neutral reason, as race-neutral a reason as it gets. If I've had dealings with 24 members of someone's family, 20, 25, whatever the number is. If I've had those kind of dealings and they pretend that they don't know me, yeah, I think that's a race-neutral reason to strike a juror. And I'm not going to go into the names, but I distinctly remember that conversation. If we need to supplement the record, I don't know how we're going to do that. I don't have access to JCATS at this point. We do have, the state has access to the prosecution computer database system. I suppose we could go through Odyssey, but that representation, and I'm not accusing anyone of dishonesty, I'm just saying that I have a right as defense counsel not to believe that answer. And that has nothing to do with whether he's black, white, or Martian. That's just the way it is. And I think Your Honor pointed out to me that just because I think that doesn't mean that anybody else has to agree. But for the purposes of this challenge, and maybe I've got this juror mixed up, but at some point, that was the gist I got from it, maybe incorrectly.
Okay.
But the bottom line is, whether the court thinks a juror is being honest in answering the questions. That's the court's determination. But whether the defense counsel thinks that they're being honest with defense counsel, that's peculiarly to defense counsel. Now, unless Ms. Dunikowski has some objective reason to suggest that that exchange with this juror was not what it was, then that is clearly a race-neutral reason.
Okay.
Independent of all of the arguments made by Mr. Rubin, all the learned arguments.
I feel like we just jumped the shark. What I heard was the proposed race-neutral reasons for striking juror 143, and we seem to have gone on a tangent about the believability of the jurors in voir dire.
All I know is that this is a subject that was discussed at length after that juror was examined during the jury selection process. At length, I went back to check and verify as best I could that I had the right person and the right family in mind. And I remember having that conversation with other counsel in this case because there was a question, and frankly, and I can only speak for me, I thought that somebody was going to come in here and reconsider and move to excuse this juror for cause. It doesn't matter whether it happened or not, but whether Mr. Rubin remembers that the conversation took place when he was speaking to you before, I think his memory is now refreshed. And now why I'm being asked to stand up and do that, I don't know. But I think the court I'm bringing the court's attention back to an obvious race-neutral reason for the excusal of this juror, or for the peremptory challenge of this juror.
Thank you, Judge.
I will address Mr. Goff's argument first. This was a juror that Mr. Goff began cross-examining, for lack of a better word. I think the court has used tone. It was obvious when the juror was seated there that Mr. Goff implied that he didn't believe him, that how could this juror not know who Mr. Goff was? The juror said, I have 12 brothers and sisters. I do not know what they do. I don't know certainly who their attorney is. Why would I be in their business? I don't want anything to do with them. So Mr. Goff's race-neutral reason of, I don't believe this juror, the state is saying it's not genuine because Mr. Goff, with this juror, his tone was cross-examination of this juror. His tone was to get this juror's back up and to imply to this juror that he was unbelievable. And the juror obviously took offense. The juror actually just said, I'm not going to talk to you anymore. So it was, in the state's opinion, done strategically by Mr. Goff as a way to have this juror give him a little bit of attitude. And we saw a demonstration of that just earlier this morning with that other juror, the female juror who came in. And I believe, in the state's opinion, that that is what was going on with this juror and Mr. Goff. It's a guilt by association. Your family has been before me or have worked with them, and how could you not know who I am? So the state takes exception with the genuineness of Mr. Goff's race-neutral reason. With regard to the other two issues with Mr. Rubin, the state was candid with defense attorneys this morning. The state went up to them and said, hey, with this particular juror, we did find her fiance on his knee before her, proposing on his Facebook page with a Confederate flag on his t-shirt. We're going to strike him. And we told him that this morning and offered to show them the photographs that we had downloaded from Facebook. In this case, we received nothing from the defense about research they'd done afterwards in order to let us know about any of these things. Right now, I have no idea if this Facebook page that allegedly has Ahmaud Arbery is in fact this juror's fiance. I don't know what her name is or anything about her. And the big concern really here is that the defense actually looked at this African-American juror's post records and went and got them. Judge, we have 2 law enforcement officers who are on this jury, former retired law enforcement officers, one from Florida, one's a federal law enforcement officer. They have not said that they went and looked at their records. They didn't pull their GCIC. They didn't pull their, that they have presented to this court at this time. So there's no evidence right now that they did this background check on every single law enforcement officer and pulled every single one of their records. But they did pull this African American juror's records. So in an effort, I'm assuming, to find a reason to strike him despite his statements. So at this point in time, Judge, we are questioning the genuineness of their race-neutral reason, and whether it's reasonable to rely on going back behind. No one ever asked this juror, well, why'd you lose your job, or why'd you quit your job, or anything along those lines, so he could address this. So this whole lack of candor, once again, you never asked me. So that's part of the problem, to go back behind them. We ask that you reseat Juror 143.
I'm gonna breathe.
Deep breath.
Deep breath. This case is important for a lot of reasons to a lot of people. And I think it's incumbent upon all of us to, as the court noted several times rightfully, don't ascribe inappropriate or bad motives until you know the facts. We're throwing out potential bombs in the courtroom, rightfully under the law. There's reasons to do it, but instead of acceding to a clearly race-neutral reason, the post records alone would be enough to unseat this or to strike this juror. Instead of doing that, we're throwing more kerosene on the situation, and I'm frustrated by that, because we had this conversation prior to this hearing about being responsible in our arguments this afternoon, whatever time it is. And so we've given the court a very good race-neutral reason with records that show this juror has a history of dishonesty with the Peace Officer Standards and Training Council. If there's some racist pretext to that, I can't understand where that would be coming from. So I'm urging the parties on all sides to be cautious in what we say in here on this issue.
That is the challenge in this motion, is that we are analyzing genuineness. And so the court understands its obligation, and hopefully everybody understands the process the court needs to go through for that. Throwing kerosene and hopefully that isn't the way folks are understanding the court's obligation. I've got to work through this. So let's try to keep it on a professional level. It's the nature of the motion itself. What's the next one?
The next one, Your Honor, is number 253 that the state raised. 253 was a juror that we moved for cause. We moved for cause based on a number of important reasons. First of all, I'll point out that the questionnaire that was originally filled out by this juror says that no one needs their life taken. I think it was wrong. So, of course, there was a great deal of exploration about that. And these are the facts that this juror believed she knew, and the opinions that she formed as a result of them. A lot of the police were in the area when Ahmaud got shot. That's all I know from watching the news. I haven't talked about it, but with all of my family, but she talked about her sister, who is in the NAACP and who had recruited her in some way for she called it an Ahmaud event through BLM. And then she was asked, would you participate in NAACP and BLM? And she said, I don't get into other people's business. But his life was taken. That's wrong. I feel like before somebody pulls a gun out and shoots somebody, they should think about it. There should be another solution instead of bam. Anytime someone's life is taken, she said, that's a crime. She was asked, is there any situation where it's not wrong to take a life? And she said, no, not really. Asked about self-defense, she said, you can't help what you do to another because of what they did to you. Well, if that was presented in this courtroom, could you give meaningful consideration to citizen's arrest? She was asked, the state asked you about citizen's arrest, what does that term mean to you? And her answer was that somebody's gotten arrested for something they were accused of doing. So her response to the question of whether she would follow the law of citizen's arrest makes it clear that it was a fairly worthless answer since she didn't really know what she was being asked about. You have to prove also. You have to come to it. Asked what does she understand the burden of proof question was by the state. She said that you have to prove. You have to come to an agreement and prove whether they were right or whether they were wrong. So for that reason, we began to set this forth to the court under what appeared to be a very clear burden-shifting argument and a burden-shifting position by this juror. For that reason, we moved for cause. The cause strike was denied, and as one would expect, that would be right at the top of our list of peremptory strikes.
From the state, 253.
Thank you, Judge. Once again, the state has not actually heard a race-neutral reason from the defense. It was a listing of everything. Once again, this woman said this woman is similarly situated to just about everyone we interviewed. In addition, I asked the court to look at her year of birth and what she does for a living. Numerous jurors came in here with no understanding of the law. They don't know what citizen's arrest is. They don't know what reasonable doubt is. They have no idea about burden shifting and who carries the burden. That is why the court is the one that goes ahead and gives the jurors the law, explains it to them, gives it to them in writing so that they can take it back. These are the finders of fact. This woman is obviously not a lawyer, so to hang their hat on, she didn't know what citizen's arrest meant as a reason to strike her. Several other jurors didn't know what citizen's arrest was, and by the time we were a couple weeks into this, we were going, you don't need to know what that is. It'll be explained to you by the court. So in this particular case, she did indicate that her nephew was in law enforcement. She'd been the victim of a burglary. She said she could give the defense a fair trial. She could consider the defenses. She's going to look at the whole case, and she would hold us to the burden. Whether she understood what that meant or not, she was willing to follow the law that you gave her. So therefore, she is similarly situated to just about every other juror who came in here, who had read the news media, who said something about, I don't really know, but no one needs their life taken. Yes, that's a simple statement. No one needs their life taken. She said she would be open to the self-defense and citizen's arrest defenses. So she is similarly situated to a number of other jurors. The defense has failed to specify their race-neutral reason that is different from every other juror that we've interviewed that had these exact same statements and concerns and indicated that they could be fair and impartial and put those initial things aside. We ask that you reseat Juror 253.
Judge, may I just briefly? The idea, is it too late?
I said early on in the process, with everybody here, what I want to do is, if we're making motions, to focus on one counsel for motions. If there's circumstances that are going to require something from all three parties, then so be it. But I don't see that as the circumstances here. I think Ms. Hogue is a fine advocate, but if she's missed something, you may want to get a note to her.
Yeah, that's fine.
Okay. Final word then on 253 from the defense.
Yes, Your Honor. To quote Ms. Dunikoski with every panel that came before us, in a perfect world, in the world that we all hoped we'd live in, if we'd ever have to sit trial for a serious criminal offense, everything would be fair. People would come in here not knowing anything about the case, not knowing anything about pieces of information and evidence that aren't coming into evidence. They wouldn't have formed opinions, and if they had, they would have automatically been kicked. But in order for us to stay in the county that is most directly impacted by this case, here we are, especially given the fact that there has been worldwide media attention. So it is not a response to say every juror said they'd made up their mind about guilt. There's nothing different about what this juror said than others. We had to rate the worst, the best of the worst. And so it's not a response to that to say, well, in Ms. Dunikoski's opinion, that particular juror would have been a little higher up on her rating system of people who came into this courtroom having already had an opinion, a strong opinion, and we shouldn't have struck her. So this individual told this court that Ahmaud Arbery did not deserve to die. It was wrong in the written statement, and that is a direct comment on the defendant's guilt. These reasons are race neutral.
Next one I have is 386.
386, Your Honor, is a juror, again, that we moved for cause. The cause strike was denied. Juror number 386 put in the questionnaire, while he did say you're innocent until proven guilty. But, he says, it seems as if Ahmaud Arbery was scared for his life and chose to defend himself against Travis and Gregory McMichael, who were both armed. So, we had to begin with that opinion based on the question, what do you think you know about this case? We had a lengthy colloquy, inquiry with this juror, and this juror was asked, have you formed an opinion about the guilt of the defendants? And this juror responded, yes. Ahmaud Arbery was scared for his life and chose to defend himself. Do you have an opinion as to the guilt of Travis McMichael? He was asked specifically about each defendant, and then asked about them all together. I guess they're guilty of, it was an unfair situation, 2 people against 1. So I guess you could say yes. Asked about involvement with organizations that are affiliated with supporting Ahmaud Arbery and his family, he indicated that he had liked a Run with Maud post, and asked what that meant to him. What were you liking when you hit that button? And I used my symbol here, pause. I actually have 2 of them. Pause. He said, I can't put it in words. It's emotion. The fact that they're trying to bring some kind of positivity to it, that's what drew him to this movement. That saying, I Run with Maud is equivalent to supporting Ahmaud Arbery. I took it, he was just out for a run and killed, and that's what led me to my opinion about Travis's guilt. Asked if he believed that race plays a role in this case, he said, I do, and went on in some detail. I just feel like he was a young black kid out running in the neighborhood. They probably didn't know him. I think the McMichaels felt threatened. This has happened to me, not to me, but to some friends of mine. And he went on about a situation where friends of his were in Minnesota playing football, and they were treated like violent thugs, stereotyped, and it wasn't fair based on people believing they shouldn't have been where they were. Asked if he thought what if this would have happened if the man running down the street was white. He said, yes, it wouldn't have happened. Do you feel strongly that this event occurred because of race? He said, from the outside looking in, that's what it seems like to me. He was asked by Mr. Hogue, how did you arrive at the conclusion that Ahmaud Arbery was scared for his life? And this juror said, because they had firearms, and that's how I would have felt. He said, fight or flight, you know. We asked the question, this was earlier on, do you think, given your experiences, attitudes, opinions, and knowledge, that you would, doing the switching, that you would want Greg McMichael, if he held those opinions, attitudes, and experiences, sitting on your jury? Objection, the court sustained. And so we never got to explore the rest of that. This juror was one that I felt we had a fairly strong cause motion for. The court denied it, and again, cause motions that are denied are always the very first of the jurors that we need to strike peremptorily. That's why we have them, and those are race-neutral reasons based on bias and already preconceived and strong opinions about the defendant's guilt.
From the state.
Thank you, Judge. Once again, no specific race-neutral reason except a reiteration of what this juror said, which was, once again, very, very similar to a number of other jurors in this case. The form says, what do you believe the facts of this case to be? And this juror started out with, you are innocent until proven guilty, and then put what he thought the facts of this case were. When Mr. Hogue was questioning him, he talked about fight or flight, but he also said the video is not the whole story. It's possible all of what we've seen is wrong, and it could be two totally different things. So he's obviously open to hearing all the evidence, just like all the other jurors who made it past a motion for cause to strike them, because they were able to put aside their opinions. Every juror comes in with life experiences, and this young man had a number of life experiences that were good. He's a manager of 3 restaurants, which is very, very good. He's got a lot of responsibility. He has gone out of state for college, had some personal life experiences there. And personal life experiences often form our opinions, but the real test here and the genuineness is this a juror who said that they could put them aside? Is this a juror who said, I will follow the law and give meaningful consideration to citizen's arrest and self-defense, just like all the other jurors? And he did, in fact, do that. This juror is similarly situated to a number of other white jurors who answered in the exact same way, where they had either experienced or knew about citizen's arrest and were able to go ahead and do something where they could put it aside and give the jurors a fair trial in this case. So we ask that juror 386 be reseated. Thank you.
Anything final on 386 then from the defense?
No, Your Honor, it's not a response to race-neutral reasons to say other people expressed having formed an opinion of guilt and having bias. So that couldn't have been a race-neutral reason given the complexity of this voir dire and the enormity of this pretrial publicity. We point out to the court, and if it becomes necessary later as you're considering what the state is, what the movement has argued, that we made many more strikes. We made many strikes as joint motions for cause against African Americans, and there was no question at that time that those issues were anything but race neutral. My opinion is fixed. So And I want to point out as well that we struck 13 white people to this number of 11 African Americans, and those were based on the same reasons, Your Honor, the same strong-rooted bias that the court either did not accept as a cause strike or did not rise to the level of cause, but gave us serious pause, that they'd formed and expressed an opinion, that they knew facts that, or believed that they knew facts that were critical to their determination of guilt.
Next one I have is 395.
I think that's what I just,
That was
395,
386.
yes, you're correct.
395.
All right, 395, Your Honor. One moment. This is the juror that we kind of gave the title of As a Parent. He wrote in his questionnaire, a young man was killed while jogging. This man raised his hand that he had a negative opinion of Travis McMichael and Greg McMichael as well, and that he knew Marcus Sr. We made a cause strike on 395, and that cause strike was denied. He knew Marcus Arbery, who was Marcus Arbery Sr., who was a couple of years ahead of him in school. He actually thought his name was Avery, and we've discovered sometime after that a number of people thought that may have been a nickname that he was using at the time. And he was asked about his questionnaire and whether he still held the opinion about the young man killed while jogging, and that individual responded, "This is a terrible case." And his response to the question about why he had a negative opinion about Greg McMichael was this, Your Honor. "I have a negative view on the father. As a parent, I couldn't imagine doing something like that with my son." He said that while the state was questioning him. That came up several times. That was really what struck this juror so deeply about what he believed he knew about this case. He talked about a service he'd been to at Bethel Evangel Community Church, where the pastor spoke about this case while he was delivering a sermon. He told us you could go and look at it. It's on YouTube. But I don't remember all that he talked about, but he talked about Ahmaud Arbery and tied it, he said, to other cases around the nation. Young black males need to be careful was the theme of that presentation. And he volunteered that he gives Ahmaud Arbery's mother credit for handling everything in that bad situation. Asked if, given all of the information that he had just provided us, if he could fairly and meaningfully consider self-defense in this case, and he said, and I quote, "Self-defense? I really don't know." Then asked to elaborate and talk more about that, he said again, "This is a terrible case, the loss of life and the handling of it." Then he moved into what he called the DA part of it, the delay, which seemed like it was just as bad after the fact. They said the DA just kind of passed it along. I really don't know. Now, we all know in this courtroom that while we have made some limitations on the parameters of the information that's going to come in that the state had initially presented during the preliminary hearing and the bond hearing about some connection between Greg McMichael and Jackie Johnson that assisted in the delay. And I'm trying to remember the word that was in the bond order, Your Honor, the word of yours. But one of the reasons that Greg McMichael's bond was denied is your belief that he could have played a role in keeping himself from being arrested. That was one of the factors this court relied on, which is available and was certainly available all over the internet. So this juror obviously had a flavor of that, a taste of that. And then again, coming out of nowhere, he's talking about this negative feeling about Greg, and he just said very candidly and honestly, I just don't understand. I can't imagine my child with a gun coming to get me. I can't imagine me getting a gun and going to get my child as a parent. This is very personal to him. He has children. He thinks very hard. He did his best to be candid with us, and we have to trust that that is how this case has impacted him. He's formed an opinion. He has knowledge outside, extrajudicial knowledge from outside that will not be presented during this trial. These are race-neutral reasons.
From the state.
Thank you, Judge. Yes, he did indicate that as a parent, he just didn't understand it. But with this juror, the reason he repeated it so often is because I have 4 pages of notes. We had this poor man here for over an hour, and he ended up repeating himself because he kept getting asked the exact same questions. So, first off, the fact that he said it multiple times doesn't indicate anything, because he also said right after that, he doesn't see it having any effect on his ability to be fair and impartial, and I really don't know anything about it as far as the case went. He did indicate that he didn't think this case was about race, and everything that he was basing this on, he said, with regard to Greg McMichael specifically, he's based it on what he believes that he got from the media. So once again, he is similarly situated to just about every juror, which is that they don't know the facts of this case. They don't know the evidence that's going to be presented in this courtroom. They are basing it on the news media and social media. They come in and they're asked to tell us the honest truth about your opinion, and can you put it aside and be fair and impartial? And they say yes. But then, in their honesty, what they've said, something that they could put aside, is then used to strike them. And in this case, it appears that all he's thinking of is, as a parent, with regard to Greg McMichael, how did this happen? But he indicated that it would not have any effect on him, since he doesn't really know anything about what took place here. I want to make sure I've covered all my notes. He especially said he's open to recognizing that the media does not get it right. He was asked about citizens' arrest. He had not heard that about this particular case, and he didn't know what that was. I don't know what happened. I have to know what happened. I'll be fair once I know what happened. So he is similarly situated to every other juror who came in and expressed an opinion. And in this case, this is a man who said he knew some about it, and all he said was, what do you believe the facts of this case to be? A young man was killed while jogging. And that is simply all he said. In this case, he did not express such a fixed opinion. We ask that you reseat Juror 395. Thank you, Judge.
Final word on 395 from the defense.
No, Your Honor, just the same thing, that's what a peremptory strike is for, to try to, in a situation like this, weed out the worst of the worst.
All right, 199.
Oh, it's me. Yes, Chair, the specific reasons for 199 begins with the quote, "They hunted him down and killed him like an animal." That opinion never changed. She felt the defendants were guilty. She felt the defendants were not arrested in a timely manner. She researched the case. She posted about the case. She said the whole case is about racism. She mentioned her 9-year-old son being a young African-American child, and had emotion about that. She works in the neighborhood. She's the mail carrier. She saw mourners, flowers, visitors, and protesters, and had experience with that as she was working for the neighborhood. Those are the race-neutral reasons. It's also a juror that we moved for cause for those reasons.
Thank you, Judge. Once again, that was a recitation of what she said. Once again, everybody came in here who had seen this media. They have gone ahead and formed an opinion. She was asked, will you consider the evidence within these four walls, willing to render a verdict based on that? I can. Follow the law, hold the state to its burden, and consider the defenses. She was asked specifically by Mr. Sheffield, could you give fair and meaningful consideration to the law of citizen's arrest? Yes, because if evidence was presented that they were trying to do a citizen's arrest, but I would do that, yes, but I have nothing on it right now. She said, for Mr. Sheffield's question, can you give fair and meaningful consideration to self-defense? Yes, I do. Could you be fair and impartial? Yes, I am fair and impartial. Actually, this juror, when they moved to strike her, it was all about the fact that she had changed her Facebook name. And that was the whole, candor with the court, she's being dishonest, and about that whole hair business where she said, I have a business, and she'd gotten an LLC, but she says it's not jumped off yet. I'm not getting any money, which is why she didn't indicate she had any sort of business. And that, I believe, was the motion to strike her for cause, not because of her inability to be fair and impartial. Once again, Judge, this is a juror who is similarly situated to all the other jurors who came in here having been exposed to news media and social media, having formed an opinion, having explained to them what we were looking for, and they agreed that they could put it aside and be fair and impartial and consider the defenses. We ask that Juror 199 be reseated. Thank you.
Final word from the defense.
One of the things that we had asked from Your Honor at one point was to allow us to go first on some of the jury selection so that we could perhaps demonstrate what happens when you ask a juror if they can set things aside. You can box things up and move away from these feelings that you have. I don't know of many jurors that came in who so expressly used the words hunted and animal. The court did excuse other jurors, and the state conceded on other jurors simply in the language of some of the things that the jurors said in their forms. So I think it is still important to consider the year and a half before that led them to give, this is not facts, this is an opinion.
.209.
I think we skipped 414, Your Honor.
That was the last one on my list. I've got 209 and 414 left.
All right. 209.
If you want to.
I'll begin, and then if you...
Sure.
Yeah. If the court's all right with it. 209 was a juror who knew Ahmaud Arbery. He had played football 2 years behind him. He had, after Ahmaud's death, he had posted hashtag Run With Maud and asked why. He said, because it stung me when I heard about it. He was asked to describe his relationship and his feelings about Ahmaud Arbery, and these are his quotes. He was a cool guy, wasn't a troublemaker, he was a jokester. And I'm posting this support for Maud to try to keep his name alive. He talked, and one moment, Your Honor. I'm finding one other thing, kind of combining different information, and I think after that, we were concerned as a group because we all agreed, including, I'm not going to speak for this court, but I know we all were the most concerned about relationships and having known a person who was then killed. And for that reason, it hit home, and it would make it very difficult for him to be fair and impartial in this case.
Right.
Right. Yes, there was a situation where the court had excused for cause another one of Ahmaud's teammates. And in that instance, the court was moved by the description that that juror gave about what he would do if he saw Ahmaud right now, and he would give him a hug. That's how he felt about him. We didn't see much difference between that juror and this one until we began to take a look at the differences in the answers that this juror gave to the questions about the opinions that he had formed. And for that reason, I'm going to now hand it over with the court's permission to Mr. Goff, who had made a motion for cause on 209 that was denied.
Your Honor, I see this juror as being, I'm not second guessing or questioning any of the court's rulings so far, but I co-counsel, I see this juror as fundamentally indistinguishable from the other teammate that was excused for cause in this case. But my point is not to question the court's ruling, but my point is, you know, when you compare the answers given by one teammate that was a year or two ahead in school, that was excused, to the answers of this juror, potential juror, as to the relationship, it felt very different. This juror was talking about he was only on the JV team. You know, I don't even recall there being more than one practice field, but it's been a few years since I've been out to the high school. They remodeled it. Well, actually, they rebuilt it. But, you know, this idea that, oh, he just played on the JV team and we didn't have any interaction. You know, the other juror had this, was in the same position, and yet he saw the situation very differently. And frankly, I think there's reason I question the candor of those responses. He said there was nothing outside of football, again, given this is a small town and we have a de facto fraternity of athletes in this town. Again, I didn't feel that was a candid response. My recollection is that co-counsel reviewed multiple Facebook posts with this juror that were troubling. He also had that's an independent one, let me come back to that. You know, co-counsel reviewed multiple, what I consider troubling Facebook posts with the juror, and while the court obviously had a different take on the answers that the juror gave and the credibility or genuineness thereof, counsel are not obligated to accept it. It struck me that on further examination, it turned out that he was also friends with a friend and co-worker of the sister of the deceased, Jasmine Arbery. He stated that he didn't keep in touch with her. They had worked together for, I recall, 4 or 5 years, but she sent him a happy birthday Facebook message in 2018. If I recall correctly, he acknowledged that. I don't recall whether we showed it to him or not. I remember asking him if he responded, appreciate it, and he said, as I recall, he said he did. And then I asked him whether he sent a smiley emoji, and again he said he did. Now, I'm not saying that the court is bound to not credit those responses, but counsel, in exercising the peremptory strike, makes their own independent interpretation. Hold on. Furthermore, I felt that he was disingenuous. That's just my take. Court's not obligated to agree. Discussing the BLM bumper sticker on his car. If I recall, he said that it came that way. And I think I asked him about it while he was here in the courtroom, that he bought it, he knew it was there, and yet he kept it on, and it felt like he was trying to distance himself from his own political statement that he had adopted. Your Honor, I'm also concerned, and it's a somewhat delicate subject, and I do want to be duly concerned as to, you know, speaking about these matters, even though the jurors' identities are not disclosed. But there is an issue in this case of substance abuse. I think marijuana, if I recall correctly, that it was, in fact, it turned out to be an ongoing issue for this young man. And that brings up several different concerns. Concern number one is the ability of this juror to concentrate throughout a lengthy trial. And, you know, that concern is emphasized further, and although he is not the only juror that is in this position, he was one of relatively few, in that he left a considerable number of blanks, that is information not filled out on his juror information card. Maybe he doesn't have a primary phone, but he left it blank. He didn't say NA. Obviously, he has an email address, because without an email address, you cannot have a Facebook account. So maybe that was inadvertent. He's got a work phone. I believe he was working at the time. But most importantly, Your Honor, he has a date of birth. He didn't remember his date of birth, or he just didn't take the time and trouble to read the directions and fill out the card properly. Again, on the form, it asks, is your primary residence Glenn County? He did check yes. The line underneath it, in caps, says since, and a blank for the month and the year. And he did not fill that information out either. And then the employer information is also left blank. You know, I'm not going to bore the court with substance abuse and what effects long-term substance abuse can have on people, but I think it's reasonable for counsel to question whether or not he would be able to concentrate and follow the directions of the court in a fairly complex jury instruction when he can't discern how to fill out his juror information card. But it goes beyond that, Your Honor. It's not just that. I'm also concerned, frankly, of another issue. The second issue is, I believe, because of this defendant's ongoing substance abuse and his interaction with GBNet, and I don't know what the acronym for the current agency is. There are certainly multiple law enforcement agencies tasked with enforcing our drug laws. But I am frankly concerned that this juror is especially vulnerable to pressure from law enforcement, or, to put it differently, the street committee. If he is out there buying and selling drugs, other people will know that. And frankly, although he is young and may not appreciate the risk, I am deeply concerned as we get into this trial, where this juror is going to feel pressure that if he does not return a verdict of guilty in this case, that he is going to be subject to retaliation. And again, that is not casting any aspersions on the young man. That is just the reality that folks don't always realize where things can lead. And for all those reasons, all of which are race neutral, frankly, I don't think there's any question that, and again, I'm not questioning the court's ruling, but in my judgment, clearly he should have been removed for cause, and certainly under these circumstances, this is exactly what peremptory challenges are designed for. You know, I'm not going to speculate as to the motives of the state about bringing this particular juror back up, but you know, it's a close question whether to ask the court to reconsider and strike him for cause at the beginning of the day. Oh, I forgot, Your Honor, one more issue. Your Honor, I'm apparently also, without realizing it, I have made a fan of this juror. My understanding is one of the specific posts that he was asked about, which I didn't actually look over Mr. Sheffield's shoulder, but he actually posted a Facebook post criticizing myself after telling the court he didn't know any of the lawyers. He had a Facebook post critical of counsel, suggesting that I had been a bad public defender. I think that was the gist of it. And both for the lack of candor in that he didn't know or know of me, again, and specifically having made that post, again, there's a candor issue there, and I don't think with respect to Mr. Bryan that he would want a juror on his case that thinks he has a bad lawyer. Certainly one that felt so strongly about it and confident about it that they would post it for all the world on their Facebook page. If that isn't a race-neutral reason to strike a juror, I don't know what it would take. I mean, do I have to handle someone's wife in a divorce case and take their house for the juror to have an issue that I would be concerned about? That Facebook post alone is a race-neutral reason.
From the state.
Thank you, Judge. And I want to urge the court to, of course, analyze the genuineness of the reasons that were just given. The state is concerned. The defense has stated numerous times that they are rating the worst of the worst. And there's 11 African-American jurors that they struck that are the worst of the worst. In addition, we now have...
Say, I don't, that's an offensive mischaracterization of what I'm saying. I'm not characterizing those people as bad people. I'm characterizing them as bad for this jury. So I just need to say that. Thank you.
Thank you, Judge. In addition, we now have this African-American young man, once again, the state's saying this is pretextual, that, oh, he lacks candor. Because you yourself, when the motion for strike for cause came, indicated how honest you felt this juror was. Because this juror admitted, oh yeah, I got caught up with this G-net situation, I got caught up with some weed, and now he admitted, yeah, I still smoke some weed. Mr. Goff has just intimated that he's now a drug dealer subject to retaliation on the streets. This sort of hyperbole lacks genuineness for an authentic reason for strike, for a peremptory strike. Basically, marijuana, what's the difference with alcohol? So nobody questioned any of these jurors about their alcohol use and what they're going to be doing in the evening at home. And this juror was forthright by saying, yeah, I still smoke some weed. The state's very concerned about the fact that he has, of course, also been called a liar because Facebook automatically tells people you're connected to that it's your birthday, so they might shoot off a happy birthday thing and you might respond with thanks. And all of a sudden he's a liar because he said, I haven't really talked to her since we worked at KFC 4 or 5 years ago, or when he was a senior in high school. Mr. Goff is correct that this is very different from the juror who was older than Mr. Arbery. That juror looked at Mr. Arbery, I think, as a younger brother, put his arm around him for hugs when he saw him. This juror was like, yeah, I was younger than him. I was on the JV team. The only relationship I had with him was football. Didn't indicate hugs, emotional relationship, never went over to his house, didn't have anything that connected him along those lines. This is a juror who said that everybody deserves a fair trial and will hold the state to its burden and consider the defenses. Mr. Goff, once again, with the genuineness, he said, yeah, Black Lives Matter. I raised my card because you said to raise my card if anything about Black Lives Matter. And I have a bumper sticker on my car, so I wanted to let you know. But it came that way. Now, Mr. Goff is intimating that, oh, well, I don't find that truthful. I think that's a lie. So there seems to be a pretextual, this young man must be a liar, he smokes weed. And, Your Honor, about this last thing Mr. Goff said about lawyers, that was brought up with the juror who said that his lawyer who handled it when he got busted for the marijuana, and then the police put pressure on him to roll over on whoever sold it to him, but he didn't know who it was that was the big cheese. He basically said that, yeah, I had an issue with the defense attorney who tried to tell him he was wrong, and the lawyer was supposed to help him. But that was never directed at Mr. Goff. That was something that was really directed at the lawyer he felt was trying to help him out. He basically said at the time he wasn't happy with the lawyer, and then was asked, would he hold that against lawyers in this case? Not really, because all you guys aren't the same. So once again, trying to make this as if this was about Mr. Goff when it was about the lawyer he didn't think was helping him with this drug case seems to lack some genuineness on that level. Your Honor, this young man, while he may have known Mr. Arbery because they played football, they were 2 years apart, he was on the JV team, Mr. Arbery was ahead of him. There doesn't seem to be any other personal or emotional connection between the two of them. And at this time, based on this, we ask that you reseat Juror 209. Thank you.
May I respond to the argument that we raised? This is a situation where we are a bit in different situations. So with respect to the response to the state's challenge to this strike, I take a different position. The Michaels take a completely different position from Mr. Bryan's counsel. I'm asking the court to find him very genuine. We believed him to be very genuine when he told this court and this room about his relationship and his feelings about Ahmaud Arbery as being cool, as being a jokester, and not being a troublemaker. Those are the reasons that we're relying on in asking the court to find that to be a race-neutral reason. Briefly, Your Honor, we go to our high school reunions and we see on those boards the names of people who have passed. And while we may not have been incredibly close then, while a great deal of time may have gone by, it hits you. You've spent a lot of years together. You've had experiences together. Those memories come rolling and rushing back in. And it's personal. You cannot have a juror who will see this as a personal challenge, as a personal issue when he's asked to make decisions about the people who are accused of killing a person he had a relationship with. And for that reason, Your Honor, this is a completely race-neutral reason because the young man was so honest and candid with the court.
May I? Yes. Your Honor, call me crazy, but when a juror gets up on the in this courtroom and he's talking about being interviewed by the police and them talking to him about the scales that they found and asking him who his supplier is, I don't think it is disingenuous for a defense.
I'm going to object at this point in time. That's not what the juror said. He said they asked him if he had scales on him, and then they wanted to turn over a supplier. So I want to correct that, Your Honor.
Thank you.
As I was saying, Your Honor, any defense counsel in any case would be wondering when a juror gives the information that they were provided, whether or not there was more to it than was actually being said. We certainly don't expect jurors to come in here and admit that they do things that they're not supposed to. I think that would be asking too much. But it is not unreasonable or disingenuous to wonder whether someone is sufficiently involved in the world of narcotics when he's being interviewed about whether he has scales or not, and whether they want him to provide information. Basically, they were essentially trying to make him a snitch, is what they were trying to do. And that gets back to the main point here, that as a juror in this case, if he's still involved, if he's still out there in those circles, and that's a legitimate concern here, then whether he realizes it or he realized it when he was sitting here, whether he realizes that at this moment, he is incredibly vulnerable. If he's still doing that, which was what I understood, he's essentially living in a glass house. And the entire power and machinery of the state is aligned against these three defendants, and that will become, and the weight of this case will become abundantly clear as it goes on. It doesn't matter what the reality is. It doesn't matter whether anyone would put that pressure. If he perceives that pressure in the middle of the trial, do we expect him to stand up and tell us? I don't think so. It's reasonable to be concerned, whether this juror understands it or not, how vulnerable he is because of the things that he does outside the courtroom. That is not disingenuous. And I will respectfully suggest that there are ample grounds for this, that this juror should have been excused for cause, but certainly failing that can legitimately and for race-neutral reasons be the subject of a peremptory strike. Thank you.
414.
Your Honor, 414 wrote on the questionnaire that she believed that her understanding of the facts of the case were, after problems in the neighborhood, 3 men decided to take the law into their own hands. I believe that guns were used when they should not have been. I believe a man lost his life when he shouldn't have. This juror was questioned about where she got the information that she based those conclusions on and those beliefs, and she said, it's everywhere. And, you know, we've said very casually and have become very comfortable with the fact that it's out there, all the facts for these potential jurors. She said, my opinion is based on 2 things, what I know about the case and what I believe about the case. do you have an opinion about the guilt or the innocence of the defendants? And her first response was, it does not really look good. Someone may have been trespassing, but that is no reason for someone to lose their life. Is that a fixed opinion? Pause. Pause. Not necessarily, was her response to the state. So the state continued to question about do the questioning that they had done about defenses. And this juror was asked, would you consider citizen's arrest? And she said, sounded as if she knew a little bit about it, she said, well, minus the guns maybe. It becomes more when the guns come into play, and I believe they could have restrained him in some other way. When the topic came back to the question of what movements she had become involved in as a result of this case, she talked about being a member or being a supporter of BLM, that she had a t-shirt, she participated in a march. I support the movement, and she thinks very, very clearly about it. So there's some of the things about the movement that she doesn't agree with. She called it the extreme stuff, but the good stuff is what causes her to be a proponent of that movement. She indicated she posted online about the case, and she'd gone back to search her own Facebook page when she realized that she was putting it down on the questionnaire, and that she had commented on other people's posts about Run with Ahmaud, Justice for Ahmaud, and Ahmaud Arbery, and asked why she had done that, and she said, is expressing my condolences. But during the questioning by Mr. Sheffield, she says, 3 men decided to take the law into their own hands, as she wrote in the questionnaire, and was asked, is that still your opinion, even after you've gone through the questioning by the state? And she said, yes, whatever was happening beforehand, instead of calling the police, it probably made things worse. Even if there had been something going on beforehand, she had already made up her mind about the fact that there was no way she could see that this was ever a legitimate, defensible act. She had thought about it a great deal and talked about guns being used when they should not have been. And she said if they had just tackled him and held him down, there probably would have been a different outcome that day. Then she was asked about her opinion when she raised her hand about how the case was handled locally. She said, I didn't know anything about it for months. Several weeks went by, and she was asked what her opinion was about that time delay. And she said it's an emotional response, sadness. She then personalized that emotion. I have 4 sons and a daughter, 18 all the way down to 11. She said it could have been me or a brother that was the same age as Ahmaud. So she has a brother that's the same age as Ahmaud. She has an 18-year-old child. She said, was asked about the connection that she felt as a result of that to Ahmaud and his mother. And she said, I definitely sympathize with her. We then asked her about the posts that were on her Facebook page concerning say his name, Ahmaud Arbery. And she said that what that connected to her was the movements with, and this is a quote, some of the other situations going on around the nation this time, to shine light on these kinds of situations. This is an example of a case that might have been swept under the rug. And that's why she was also a proponent of something called Project Light, which supported the initiative for Georgia's hate crime bill. She said, I think it's a good idea to have a hate crime in Georgia, and I believe it came about as a result of this shooting. She was asked if she believed racism played into this case. She said that she tries not to look at something immediately and see that. She's deeply thinking about these things. But I would like to believe that it would have happened if Ahmaud Arbery was white. But I can't pretend it's not there. I just can't. In this environment, in this climate, in this culture. She said that one other thing that really affected her is that her children have seen these news reports about Ahmaud Arbery. And she said that is not an easy thing to see. To see the children that you love and that you wish to protect see this death of someone like them with the skin color that they share and in some instances near in age to this young man. She said, so as a result of that, she is now counseling her children that if someone has any reason to assume you shouldn't be where you are, don't be there. That's what in her mind has grown out of this event in her life. Those are race-neutral reasons, Your Honor, and I'm sorry, I have a little note from this is a very good and interesting exercise that Mr. Sheffield is trying to do very quickly for us, if the court will need that as you're taking this under advisement. And that is that when we went through a rating system for these jurors, we used a very particularized rating system that we would keep up with every single night, exhausting as it was when we got home. And the rating system was based on characteristics concerning the answers that we saw on the questionnaire and the information we received in this courtroom. There is not a juror that we agreed to seat that we rated down in the 1s and the 2s that said anything like the kinds of things I've been reading to you today, Your Honor. And if necessary, depending on how deep of a dive, to use Mr. Sheffield's phrase, you are going to be making into this, I don't see that it requires a deep dive because these are race-neutral, legitimate reasons for striking and exercising our peremptory strikes. But if you do need that, we would be happy to prepare that over the evening break.
Thank you, Judge. I'm also going to ask the court to take a look at how much time was spent with each and every one of the African American jurors. Once again, this isn't 1 page of notes, this is 4 pages of notes. Mrs. Hogue just went through all of that. We got down to even talking about the kids having watched this on TV and talking about questions. No other white female juror got into, well, have your kids seen it and what did you talk to your children about and how did you get into that? But with African American jurors, we went down this path, deep dive into their lives over and over again with 4 pages of notes, where a lot of the white females, no questions were asked. In this case, I want to point out that while she talked about the hate crime bill, she then said, the hate crime, I don't know that yet about this case. And that was something that was glossed over during that. She says that she hopes racism did not play a part in this case. So once again, this juror is similarly situated to every other juror who came in here and was asked, what do you think you know about this case? And she basically said, three men decided to take the law into their own hands to stop who could or could not have been trespassing in nearby homes. When she was asked by Mr. Sheffield about, can you assure us, basically, can you assure us that you'll be open-minded and consider the evidence? She said, yes, I'm going to listen to all the evidence. This is no different than any other juror that he asked that exact same question to and received the exact same answer. So this juror, while there was a lot of reasons, there's 4 pages of notes with a lot of time spent with this juror, deep diving into her life. And the genuineness of the list and litany is no different than any other similarly situated juror. We ask that you please reseat Juror 414. Thank you.
Your Honor, my response to that is this. Number one, that argument pretends as if the reality is not what it is. It's as if we were trying a rape case and Ms. Donikowski would say, how come you didn't explore that more deeply with the men on the jury? The idea of being accosted, the kind of feelings that you would have about that, the kind of things that only those jurors that were women would feel. So the idea that we would be questioning jurors who made very clear statements about their opinions about this case and the role that race played in this case, as we did with a number of white jurors who had strong opinions about race and the role that race played in this case. Those are the folks that we're going to do the deep dive with. And if a juror says, I don't see race in this case, or I don't even have an opinion, or, you know, my husband says they were defending themselves. Well, of course, we're not going to do the deep dive. It's a disingenuous response, no different than when the state had the opportunity to do the first questionings and a juror would say, I do have an opinion. What is that opinion? I think that these guys might well have been defending themselves. They weren't then asked about their ability to set that aside. You know, they were then, we do the cross-examination
I would
deep.
suggest you get off this because I distinctly remember an African, I don't know whether it's one of these, I have to look at my notes, I was asked, do you think race plays a part? No. Well, are you aware other people do? Yes. And then all we want to get into is, well, what do you think of their opinions? So I would suggest that this may not be the strongest argument. Let's focus on your specific reason with regard to this juror.
Well, our specific reasons with respect to this juror were raised, again, during our motion for cause on 414, for the same things that we raised here, and the court denied that motion for cause. For those reasons that were race neutral, having to do with the strong feelings that this juror had and the emotional and personal connection that this juror felt to the event and her own situation at home with her children.
I believe that is the last juror of the panel that the state has brought up in the reverse Batson McCollum. Let's go ahead and take a short recess. I'm going to take a look at notes and figure out what I've got, and then we'll start addressing these in turn. Thank you.
Please proceed.
All right, we got the defendants present represented by counsel. We're back on. All right, the matter before the court, reverse Batson, however you want to describe it. The court, when this type of motion is brought before it, is asked to do really two things, make two primary findings. The first of which, this court has found that there appears to be intentional discrimination in the panel. That's that prima facie case. And I guess before I get into this, one of the challenges that I think counsel recognized in this case is the racial overtones in the case. And those can't, at least here, without the jury present, based on the questioning, we have not been able to escape those discussions with the panel, and they've just come up in a lot of different contexts. So, you know, this is sort of a continuation of a conversation that I think will continue for a long time with respect to this case and maybe many others. And so we start getting into this question about race. And again, quite a few African-American jurors were excused through preemptory strikes exercised by the defense. But that doesn't mean that the court has the authority to reseat simply, again, because there's this prima facie case, because we see it. It's sort of one of those, it's not one of those we see it, therefore it is. There's now additional steps the court needs to engage in. One of those steps is the exercise we just went through, which is going through those particular strikes and hearing from the defendants in this particular case on a reverse Batson on why those strikes were exercised. And then based on all of that, the court is in a position where it's got to make another finding, which is that the defendants are not genuine when they gave a reason, and that the reason they were claiming is not the real reason those particular jurors were struck. Batson is very limited in what it actually provides the court with as far as an instrument, because, at least in the state of Georgia, the court, if it hears a legitimate, non-discriminatory, clear, reasonably specific, and related reason, and reason related to the case, that is usually enough to get the court to a finding in this third phase where the panelist doesn't need to be reseated. There are other states that have a different approach, actually get much more specific. I'll point to Washington as one of those states that's looked at Batson and recognized the limitations it places on the court. But effectively what the court's being asked to do here is determine whether or not the defense is not being genuine with respect to these strikes. And there's all sorts of case law out there, including case law about whether or not you're treating, in this case it would be African-American potential panelists versus Caucasian, how specific the questions have to be and how closely related they are. And I'll tell you, in this particular case, Batson's limitations, I think, are clearly out there. In this particular case, there are these significant overtones of race to begin with. And then we have numerous additional preemptory strikes. We're not just limited to the ones that statutorily sit out there. And then we have extensive questioning of each of the panelists, which start differentiating everybody for different reasons based on answers that are given. Because of that, it becomes very difficult for the court to start working through this problem of, are these really genuine reasons that are out there? And
it gets to the point that I think was raised actually in the Batson decision. I wrote it down. It's Justice Marshall in his concurrence was talking about Batson. And he said specifically, the decision today will not end the racial discrimination that preemptories inject into the jury selection process. And the reason he said that was because his view of it was that preemptories just give the parties the opportunity to place the court and the system into this this balancing of race versus legitimate purpose. And again, this case makes it difficult because race has been injected into this process, and we have a significant number of preemptories. All that's to say, I've worked through each one of these. I've listened to the defense. Again, in the state of Georgia, all the defense needs to do is provide that legitimate, non-discriminatory, clear, reasonably specific, and related reason. I have very adept counsel here, and they've been able to explain to the court why, separate from race, those individuals were in fact struck from the panel. It does not change the fact that that initial finding was out there. It doesn't feel like that is how it worked, but it's been explained to the court under the terms of Batson why those particular strikes were made. And the court is not going to place upon the defendants a finding that they are being disingenuous to the court or otherwise are not being truthful with the court when it comes to their reasons for striking these jurors. So because of that, and because of, again, the limitations I think Batson places upon this court's analysis, I'm denying the motion. Anything from the state?
Nothing other than scheduling and the future. Other than that, nothing.
From Travis McMichael.
Thank you.
Your Honor, I just want to place something on the record with respect to the court's comment of Justice Marshall's opinion that Batson won't end racial discrimination in jury selection. And I say this on behalf of a team of lawyers who have been very careful about all this and have had to juggle and weigh all of these interests, that what the court found is what you would have found is no discriminatory intent in exercising the peremptory strike, that you found that they were genuine and race neutral. So I point out that in a normal case, anything outside of what we're doing here today, the three statutory questions the court would have asked: have a juror formed and expressed an opinion? Is your mind perfectly impartial between the state and the defense? Is there any bias resting on your mind, either for or against the accused? In most cases, when those jurors raise their hand, that's the end of the inquiry. In some cases, they're called in to discuss that, and if they still hang on to those opinions, they're off the jury. So what I wanted to make clear to the court, to the gallery, is that what we have to do in a case like this is to scrutinize the ability of those jurors who said, I have an opinion and I feel this way about the case, but I understand the law and I aspire to put my opinions, knowledge, and relationships aside. And in scrutinizing those jurors' ability to do that, what becomes clear is the court's opinion in Georgia versus Collum, the case we're here on today, in that Justice Blackmun says very clearly that there's a distinction between exercising a peremptory challenge to discriminate invidiously against jurors on account of race and exercising a peremptory challenge to remove an individual juror who harbors some bias or prejudice. Batson was meant to address stereotyping, drawing inferences about a juror's ability to serve based solely on his or her race, and we stand as a team to make it clear to the court, and I appreciate the court's understanding that that is not what we did, and that we had to accept the realities of the limitations of what kind of jury panel we were left with, given the notorious nature of this case and the overwhelming publicity.
Well, the court's already indicated where I sit on it. That is
with the defense's position, and again, I've explained what I believe are the limitations with regard to Batson in this court's analysis. Under the circumstances of this case, I explained my ruling, and that's where we are. All right. What I'd like to do then is let's go ahead and move the 16 that we have into the courtroom, or I guess right now we've got 15, and then the 16th is a member of the panel. And I'm going to go ahead and pull them together and get everybody's final statements on the process and probably break for the day.
Your Honor, if Ms. Dunikowski or somebody else wants to speak, but somehow there are some tasks that always seem to come to me. I think it is the decided opinion of all the lawyers on all sides of this case that it will be impractical to commence opening statements in the morning. On a scale of 1 to 10,
Let me take care of the jury before we start getting into all this. I'd like to get these individuals who've been here since 9 o'clock this morning clear, and then we can deal with whatever we need to deal with.
I only brought it up because if you release them with direction when to come back, it might be helpful to have that discussion before they go. But I will sit down.
The court's already thought it through a little bit. I guess I'll just throw it out there. We got a lot of legal issues to get through. My intent is to bring them back at 9 o'clock on Friday morning, and hopefully by that time we'll be ready to go. So hopefully that solves the problem.
Thank you, Your Honor.
Your Honor, are you shuffling the deck the way that there had been a description since?
I'm not sure how their numbers are coming in. The instruction to the clerk is to go ahead and shuffle the numbers.
Very good. Thank you, Your Honor.
Okay. I do see the clerk in the court. Are we able to pull the individuals that we have in? Okay. I'm going to need the left side of the gallery cleared. Juror number 168. Juror number 234. Juror number 258. Juror number 380. Juror number 496. Okay. 579 we've addressed. 580. Got it. 195. 274. 281. 282. 773. 364. And 440. All right, I think that covers everybody. All right, we have the group. All right, ladies and gentlemen, those of you who are here and whose numbers were just read, you are going to be impaneled as the trial jury in the state of Georgia versus Travis McMichael, Gregory McMichael, and William R. Bryan. So, at this point, what I'm going to do, it's going to be relatively simple, is we're going to give you some instructions. So I'm going to have you go over to the grand jury room and get some instructions about reporting and some of the things about being a juror in this case. And then I'm going to ask you to report back for the beginning of the case starting at 9 o'clock on Friday morning. The instructions I'm about to give you, you will hear over and over from me. Again, do not discuss this case with anyone. Do not let anybody discuss this case with you or in your presence of hearing. And do not go looking for any information about this case. If you've got a news feed, social media, whatever it is, I suggest that you turn it off. Okay? Don't pick up the Brunswick News or the AJC or whatever newspaper may come to your house. You can give it to somebody that wants to read it. But again, do not discuss this case amongst yourselves or with anybody else until you are told to do so by the court. Don't go looking for any information, and if anybody approaches you about the case, please let me know. And again, if anyone's talking about the case around you, just walk away. Tell them politely that you can't be around them. And if you run into any issues, please just report those to the court. Okay? You're going to hear me thank you over and over and over again as we work through this case. You'll understand how important it is to act as a juror in Superior Court, not just in this case, but generally. Your role is critical to what we do here in Superior Court. You are now a part of the function of the Superior Court. And I appreciate the fact that you're willing to serve, and I thank you for doing that. So, with those instructions, I'm going to have you go ahead and go with the sheriff into the grand jury room. I'm going to have him keep you with the rest, or I'm going to have you keep you for just a little bit. I'll tell you what we're doing just to make sure everybody's comfortable with what's happening here. We're going to be taking some steps that the sheriff's going to explain to make sure that you're able to come in and out of the courthouse without any issues. I'm going to be releasing everybody today, the whole group of 64 altogether, so nobody will know who of that group actually is on the panel, and you'll be able to stay relatively anonymous that way, but the sheriff will give you some more information when you get into the grand jury room, okay? So, it's been a long day for everybody, okay? I will tell you this, once we start this case, we're not keeping these hours, okay? I'm sure the lawyers will be relieved to hear that also. But the day will shrink down a little bit. I appreciate everybody's time and the investment in time they've already made in this case. Okay. Thank you. If you could just go ahead with the sheriff.
All right, for jury, please.
I saw so many happy, smiling faces when they came in. I forgot to ask while they were here. Any objection to the method or selection of the panel composed other than what is already on the record from the state?
Nothing else from the state, Your Honor.
From Travis McMichael.
No, Your Honor.
From Greg McMichael.
No, Your Honor.
From Mr. Bryan.
No, Your Honor.
Okay. The panel will be sworn and seated then on Friday. All right, so Friday we'll go ahead with that group. They'll be here at 9 o'clock. Hopefully we can get to openings in this case by then, but that gives us a little bit of time Friday if we need it. I imagine Thursday will be spent addressing any motions before the court and then getting everybody acquainted with the courtroom itself and whatever we need to do to ensure that everybody is able to present what they need to present effectively and efficiently. That is the court's plan. It's a little bit different than what I stated yesterday, but we all change a little bit. So let's plan 9 o'clock tomorrow morning.
I was just hopeful for the 10 o'clock, but I'll be here at 9, yeah. Yes,
Well,
Judge.
the way we tend to fill time, until I start feeling comfortable with you all being able to do something before 6 o'clock in the evening, we'll keep starting at 9. Starting at 9. All right. All right, anything from the state before we recess?
No, Your Honor.
From Travis McMichael?
No, sir.
From Greg McMichael?
No, Your Honor.
From Mr. Bryan?
No, Your Honor.
All right, we are then adjourned until 9 o'clock tomorrow morning.